You are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Is now in session. All who have cause to plead, draw near, give attention, You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Supreme Court. The first case on our docket today is Johnson versus the state of Florida.
Good morning. May it please the court. I'm Mark Gruber with CCRC representing Emanuel Johnson. What I would like to ask the court to address are the first thing is what's actually in the reply brief is the failure of counsel to lay a predicate for the introduction of certain out-of-court documents, meaning the Sarasota jail records, which reflected a suicide attempt by Mr. Johnson, whereby he slashed his wrists and then later on was trying to chew them out with his after he was back in the jail, and also a previous suicide attempt and some other matters. And in that situation, defense counsel tried to introduce these documents during the penalty phase of both capital trials, and the state objected because he hadn't laid a predicate, which he had not. And then the same objection came up again later on in the second trial, and there was a reference back to the previous record and the same exchange occurred. The other thing, if we get to it, is I have an argument here about inconsistent defenses, and I've actually listed about 5 sort of basic defenses that the defense was trying to present, and that ties in with what I've argued is a premature disclosure or disclosure at all in certain cases of confidential expert advisors who wound up to the point where the state on a couple of occasions was threatening to call one former confidential advisor to testify in rebuttal to a previous confidential advisor, all of whom had been disclosed at that point. With regard to the first issue about the introduction of these records, as I said, they talked about a couple of prior suicide attempts. Counsel had them. Now, on direct, and they would have supported the eventual defense request for statutory mental mitigation, and at least would have enhanced some mental mitigation or non-statutory mental mitigation, because what eventually was presented to the penalty phase judge was simply the unsupported testimony of lay witnesses. There was no expert testimony presented in support of mitigation at all. And it's also worth noting that
the suicide attempts were when in relationship to the murder?
Well, the actual case took about 3+ years to work at the trial. The suicide. Let me see if I have it.
Were they? In other words, were they while he was incarcerated after the murders?
Yes. While he was incarcerated awaiting trial on this case, he attempted to commit suicide, and I'm looking at my notes here, and I don't see a precise date for them. I believe it was shortly after, within a matter of months after the arrest.
And so your argument is that, I mean, let's just, that the records didn't come in, but they weren't, I mean, if they came in, how would that undermine confidence? I mean, how would that change the picture of the aggravators and mitigators? I guess I'm having a hard time sort of connecting it all up unless a mental health expert was going to explain some history of depression, suicide. I mean, someone trying to kill themselves after they've committed murders, I'm not sure that's how mitigating, that is?
Well, these were records that were from the Sarasota jail, as I said, and presenting the predicate to introduce them would have been fairly easy, and counsel was given the opportunity to do that and didn't do it. There was also a prior suicide attempt when he was 13 or 14. At least I'm alleging that there was. Now, the issue about having those records explained was certainly brought up during that was one of the basis for the state's objections, and that's one of the basis for the lower court's ruling. We have an argument here.
That is what? They weren't tied up to something? You just don't put them in? What's the relevancy? Was that the objection?
Yes, they presented family members and people that the defendant had worked for, lay witnesses. In other words, they did not present any mental mitigation. We argued that one avenue that could have been used to tie this up would have been a mitigation expert, but that was simply one avenue. They also had Dr. Afield, of course, who would have testified and did testify at the evidentiary.
I guess we're talking now about the original trial.
Yes.
And the lawyers tried to put in these records, and the state objected. Mm-hmm. And now what you're saying is that even though they tried and it was the objections were made, that they were deficient in not doing what?
Well, in laying a predicate for the introduction of the records.
How would the predicate have been laid?
Simply by calling the custodian of records at the Sarasota jail would have introduced the jail records. And at that point, once they're authenticated.
Was that the objection, authenticity?
That was the argument from the state. Yes, lack of laying the predicate, lack of authenticity, and that's actually what the court cited on direct appeal when this issue was raised. The argument then, of course, was that the court erred by not allowing them to come in. Defense counsel argued that they were self-authenticating, which of course they aren't. But there also was an objection, which I think Your Honor was getting at, which was that they needed to be explained in some fashion. Now, these were composite exhibits, and there was also discussion on the record about the alleged suicide attempt where he took an overdose of sleeping medication, which I think would suggest a suicide attempt in his teens.
But could you explain, maybe just in a couple of sentences, explain, the jury hears that he tried to kill himself while he was awaiting trial, or, I mean, there's several, I mean, we're dealing with a man that had several crimes, and he tried to kill himself when he was 13. So now, what's the next? Okay, so.
Well, it would supplement the lay testimony that's presented through his mother and through his wife and so forth. That he's troubled, that he was headbanging as a child, that consistently, that he at one point was, they consistently called him crazy because of his behavior. There were outbursts, difficulty in socializing him at all. That
was there testimony about the suicide attempts?
Yes, there was. There was lay testimony.
Was that contested in any way?
No.
So there was testimony about this that was uncontested. I'm having a hard time seeing what I think it's Justice Garandy, what would be added by the records. I can understand why it might be good to get them in, but the fact that they didn't come in this context that we have here, how that would undermine our confidence in the sentence, it seems to me to be pretty hard to put that together.
Well,
help me.
In and of themselves, all right, that would be a point, but it also needs to be considered that there was evidence on the record from Dr. Afield that the defendant was psychotic, that he suffered from schizophrenia, autism. And there's the fact that the defense strategy was to argue for the statutory mental mitigators. These records would have at least taken a step in that direction of
But there's
proving.
no... You make arguments that there should have been a mitigation specialist.
Yes.
It's not, that person's not an expert to be able to explain behavior. They just gather information. The judge found on that, the post-conviction court, that basically there was an investigator who went out and essentially obtained the same information that this now mitigation expert looked at. So now we're looking, to me, at a hindsight thing. Then there were several mental health experts that were hired, and the experienced defense counsel made a strategic decision not to use them. Now, I know you argue, well, if they hadn't done this, this wouldn't have happened, but for the guilt phase. But the judge, again, the post-conviction court made findings on this. You didn't bring, I mean, there's not another mental health expert that somehow would put this whole case in a different light. I mean, there were, the judge in the original trial found that any one of the aggravators in this case would really outweigh the mitigation. And you're dealing with a case of just serious weighty aggravation. So I'm just having I understand, you're representing your client and doing the best job you can under the circumstances, but I don't see anything that is just, if this had come in, this case would have been a different case.
Well, I'm maintaining that there was evidence, there was greater testimony presented from Dr. Ayfield in the evidentiary hearing than there was at the in the trial proceedings. But
how do you get around that it's that the finding that it was tactical, that it was a reasonable decision? It's not like they didn't hire mental health experts or have them, but they made a decision not to use them. And it's not that they didn't investigate, they did, and then they presented lay witnesses. Now I know that we said on direct appeal that it was pretty shaky testimony. It was either uncorroborated or whatever, and is certainly there. But I don't see that there's a new picture being presented at the evidentiary hearing that would say that these lawyers were deficient in what they did.
There's, because of the age of the case, all right, there's a twist in this case. It was pre-Spencer at the time of trial. And the judge who heard the penalty phase evidence, which was only the lay witnesses, there was no expert analysis of that information at all, was not the judge who heard testimony from Mayfield or from the other mental health experts that was presented at the suppression hearing, and he explicitly said that he would not consider that evidence in passing sentence. There was also not, of course, a separate proceeding where defense counsel, if they wanted to avoid certain effects, could have presented that evidence to a judge outside of the presence of the jury.
I guess what I'm looking for is a word picture of what is now there, that if the jury had heard it, the judge had heard it, that the whole equation of whether to impose the death penalty would have been dramatically different. That's, that's what we look for in these cases, to see if whether it's deficiency. I'm not sure I see it, but even assuming it, where is that dramatically different picture?
Well, that was what I was trying to get at, is what the judge and the jury heard was no expert testimony, nothing about schizophrenia, nothing about any expert testimony backing up any mental health defects other than lay testimonies that essentially said, well, there were these problems and suicide attempts and things of that sort. None of that was presented at the trial court level or considered by the trial court level in the context of a penalty phase, in the context of either statutory or non-statutory mitigation. Of course, the trial court did not find that there was evidence to support statutory mitigation, and as far as the mental mitigation, the only basis the court found for it was the defendant himself during his statement saying that he felt pressured, and I believe he commented that he didn't find any corroboration of that evidence. So the evidence for mental mitigation that was presented at the trial level was very close. It was very, very minimal. What I'm arguing is that what has been presented since then and should be considered in the penalty phase context is evidence of schizophrenia, of autism, backed up by expert testimony. I hope that's an answer. What also feeds into this is the fact that a notice of intent to rely on the insanity defense was filed very early on. Dr. Ayfield was retained by defense counsel, and it's impossible to conduct an evaluation with regard to insanity at the time of the offense and with regard to the statutory mental mitigators without making an inquiry about what the state of mind of the defendant at the time of the offense. So Ayfield did that. And then later on, virtually a year later, the defense focused on the statement, focused on essentially Fourth Amendment issues and Fifth Amendment issues, and that resulted in a number of hearings in an effort to suppress the statement, suppress evidence. And during the course of those hearings, particularly with regard to the interrogation of the defendant, the defense presented expert testimony with regard to that. They also presented Dr. Ayfield. Now, Dr. Ayfield was originally a confidential advisor. Then he was disclosed. The circumstances of his disclosure are a claim of ineffective assistance of counsel because of the way it was done and because of the fact that you have really inconsistent defenses. And as I said earlier, it resulted in the point where you had one confidential advisor. The state was threatening to call one if the other testified, and that happened a couple of times during the course of the case.
You, counsel, as you have noticed, they are into your rebuttal time. You have a total of about 3 minutes left.
Right. I'll reserve that time. Thank you.
May it please this honorable court. The honors, my name is Catherine Blanco. I'm with the Attorney General's office in Tampa representing the state of Florida.
Can you explain why a case that was decided on direct appeal in 1995 is just now coming up, two cases of murders coming up in 2012 to this court?
Your Honor, I've looked through the record to try and explain what was the delay in this particular case. I believe part of it is largely attributable to the fact that CCR was representing the defendant in the non-capital cases, and the state repeatedly sought to and asked the trial court to disqualify CCR with the argument that CCR was not statutorily authorized. As the case proceeded below, essentially all 4 cases were combined for consideration at a Huff hearing for hearings throughout several years. The state's efforts were unsuccessful in having CCR discharged at the trial court level in post-conviction. When the Kilgore decision finally came out of this court, I believe in 2008, the state renewed that objection and presented a renewed motion before the trial judge, and the trial judge denied it. So some of that delay was attributable, in fact, to the fact that CCR was representing the defendant on the non-capital cases without authorization, and the state went to the 2nd District at one point to try and get an order enforcing what we believe were the statutory requirements, as this court has ultimately found in Kilgore. Now, candidly,
I'll tell you, it's not probably at this point worth going through all of this. It's just, of course, it's just you've got 2 very significant murders, and these are cases that require the utmost attention to this court, and we would hope for the Attorney General's office in moving these cases along. But let's go to the merits of these cases. And are we talking here, and we have two separate murders?
You have two separate murders, two separate trials. The cases and the sequence they were tried closely in chronological order with respect to the way they were committed. The non-capital cases, the victim Cornell, the victim Giddens, the defense had filed a motion for speedy trial in the White case, which accelerated that before the Jackie McCain case.
But I guess what I want to ask is, with the two separate, we're only here on are we here on just the murders?
Just here on the murders. The non-capital cases are pending in the second DCA.
Is the exact same argument about whatever trial counsel didn't do in one is the exact same argument of what trial counsel didn't do in the other? The same lawyers in both cases?
Same lawyers,
and
three
same
trial
exact
counsel.
way that they presented the mitigation? Nothing different?
Well, there are slight differences, and perhaps Mr. Gruber can clarify that on his rebuttal. But my reading of the case is that, for example, they have a claim that relates to two of the non-capital cases, which really is not properly before this court. But the bulk of their complaints are that trial counsel, the three trial attorneys, which is the public defender for Sarasota, Elliot Metcalf, chief assistant public defender Toby Hockett, and assistant public defender Adam Tabrugi, that they mishandled all of their, or three of their expert witnesses, excuse me, not all of them, but three of their expert witnesses. That's the argument, and it applies to both cases.
But in neither case was there expert mental health mitigation.
Well, there was much attempt to have doctors examine the defendant. I think there were at least 8 doctors. It was not presented with an expert witness.
Okay, so because the statement that the court made on direct appeal, well, maybe it was the state's comment, the evidence of Johnson's mental disturbance in the penalty phase came largely from anecdotal lay testimony poorly correlated to the actual offense at issue. Is that the case for both of them, that it was sort of anecdotal lay testimony that was really not correlated to the offense? I mean, would that accurately characterize both of the murder cases?
That was this court's finding, Your Honor, but it
in
also...
Both, what I'm asking is, that's the same characterization in both cases?
It was lay witness testimony.
So even, and I guess the question I always would have, and I haven't analyzed each one, usually, and what was the jury vote in both cases?
You had an 8-4 and a 10-2.
The first one tried was the 8-4?
The White case was tried first because of the speedy trial motion. And that's the victim with the 7-3, a 73-year-old victim, over 20 stab wounds.
So was that, what was the jury vote on that?
That was the 10-2.
Okay, so the issue about how you then present a next case, was there any discussion that after we defended this case and put on the penalty phase, we now really looked at it and we thought we better change our strategy? Was there any, I didn't see any of that, but was there any of that discussion that we ought to take a different tact? We have now the judge's sentencing order. We know that this lay testimony isn't going to fly, so we better find ourselves another expert. Anything like that? And I'm just, I didn't see it. I'm just trying to understand.
In post-conviction, defense counsel testified uniformly that their strategy for the penalty phase was to get as much background information as they could on this particular defendant. They sent a mental health, they sent their in-house mitigation specialist, Beverly Ackerman, to Mississippi.
So the answer is no, it didn't change from one trial to the other?
It remained lay witness testimony. But, Your Honor, the sentences were not entered at the time before the McCann trial. The sentencing was deferred. And so what you have is an emphasis certainly on the mental health mitigation. But there's one thing I would like
What do you mean an emphasis on the mental health mitigation?
Well,
I thought there was no mental health mitigation.
The defense emphasized mental health mitigation in the sense that they said, defense counsel, for example, in his closing argument at the penalty phase says, look, all of these witnesses say that the man that they know could not have done this type of offense. If he did, he must have snapped.
How do you? But I
this
guess
is not the man they know.
How do you make I guess the question I have, and I'm not sure that they've presented on post-conviction anything that will really help in the end, but how do you make that argument without having a mental health expert pull it together?
Because you make it by virtue of the defendant's own statements as to the pressure that he was under. Remember, they do have the defendant's statements. There was an interrogation of the defendant. There is a transcribed and tape-recorded statements where he's saying the pressure was building up. I don't know, the pressure, trying to bring it in to some point in time as to what was going on at the time of the crimes. But I would like to just briefly respond, I believe, to complete the record, because Justice Periente, you asked me about the anecdotal lay testimony, and then in this court's opinion, this court goes on to say about the psychological experts that had testified to Johnson's mental state in their earlier suppression hearing, though counsel chose not to bring those experts before the jury at the penalty phase. Even then, Johnson's case for mental disturbance in the suppression hearing was partially controverted and is itself consistent with the trial court's conclusion that Johnson's psychological troubles did not rise to the level of a statutory mitigator. Mr. Gruber has argued this morning that Dr. Afield really should have been called at the penalty phase. Trial counsel in post-conviction uniformly confirms that a decision was made not to use Dr. Afield for any reason. Now, as to the inquiry with regard to the medical records, Mr. Gruber's first argument had to do with the medical records that was not admitted, and he candidly admits that lay testimony was presented as to the defendant's suicide attempts. The medical records, Your Honor, wasn't just a predicate objection. It was also an objection that the records were not complete in themselves and they required interpretation to be understood. That has not changed. The medical records are in, and I actually have the direct appeal out of 78336. The records, they're not very lengthy. I think you have a total of 7 pages, 2 of which are legible with respect to someone's statements. One is a a statement by an LPN. It's at page 8677 of the record, and then at page 8678 is a statement by another RN. Those statements indicate that the defendant was taken to the Sarasota Memorial Hospital during the night. He had slashed his wrist of the left arm, follow-up orders, changed dressing, ice packs. Subject will be moved to the infirmary at the jail and observed. The date is April 18th because, Justice Periente, you had a question with respect to the timeline. The first report is April 15th of 1989. The second is April 18th of 1989. The defendant was arrested in October of 1988. And this is the remark: inmate pulls stitches out of his left wrist with his teeth. Wound is wide open. Inmate said he doesn't want any more stitches. I butterflied the wound closed after cleaning with peroxide, and clean dressing was applied. We will change the dressing on a daily basis. So that's what we're talking about as to those medical records. Now, what do they mean? Because the defense was, objecting at the time, or seeking to admit those records, and the state says, they require some explanation, because is this a feigned suicide attempt? Is this somebody that wants to get a field trip to the hospital because it's much nicer there than being in the county jail? So we have to look back at what the defense knew at the time they decided not to use Dr. Afield. CCRC argues that Dr. Afield should have been called to get these records in. Well, we do have the 1990 deposition of Dr. Afield, which the trial court in post-conviction included in the record. It's in the post-conviction record, volume 31, of Dr. Afield's 1990 testimony, so we know what Dr. Afield knew about this. Dr. Afield is asked on 5909, Was there any indication whatsoever that there was any organic brain damage? Answer is no. On page 5914, Dr. Afield is asked as to what he has reviewed. What's the next thing you had? And he says, a report from Diana Reddy of 1/15/89, nurses' notes at the hospital and jail. Is this after he's been arrested? Yes, and Dr. Afield says, Dr. Afield is asked, and what, if any, bearing did that have on your ultimate opinion? Same thing I've told you. I mean, the guy's depressed, suicidal, and that's all it is. Question, does that give you any bearing as to what he was thinking of at the time of these offenses? Again, the statutory mitigator, they're going after mental health. Answer, no. Just as it's all the more reason to say he was crazy. So that's what the defense had and knew at the time they made a decision not to call Dr. Afield. Now, the trial court in post-conviction says, you know, Dr. Afield would have come with a price. And the price would have been the possibility that you get contrary expert opinions. And you have a report from Dr. Marin that's in the record.
Well, wait, the issue of that you might get contrary opinions, you mean between two of the defense experts or between the state expert?
No, this was an expert. This was not a defense expert. This was a court-appointed expert that the
but
that was disclosed.
Where would the contrary opinions come from?
The contrary opinion would have come from Dr. Marin and Dr. Spray, who were not confidential experts.
But I guess in every case, not every case, but a defendant puts on a mental health expert, and the state oftentimes puts on their own. The idea that you wouldn't call somebody because you might have a contrary expert when you're faced with these horrendous murders that are, you know, with this, as you mentioned, stabbed 19 times, against, as you said, this 73-year-old woman. It's just to say that that's a reason not to call somebody. I can't imagine that alone would be a very good tactical, reason.
The decision was made not to call Dr. Afield in part because they found that he was a flip-flopper, or at least that was a very experienced trial counsel's assessment, thought that on cross-examination his opinions would not hold up.
But I guess, so, and we don't have now a new expert that comes in that kind of wraps this all together to explain how or if Emanuel Johnson flipped, on the days of either of these murders, right? There's no other mental health expert. All we're doing is saying the people they had, now we're questioning whether they should have been called. Is that what we're dealing with?
You're dealing with the experts they've had because Dr. Afield was the only expert called in post-conviction. He was the expert from one of the defense experts, one of the half-dozen defense experts that were consulted.
And that's important that we want. They consulted with numerous mental health experts. And so it wasn't just Dr. Afield. There were many that they made a decision, a tactical decision, that this mental health testimony wasn't going to be strong enough to outweigh whatever other problems they thought would come up, correct?
That's correct, Your Honor. Okay. And we have a footnote, I believe, in our brief that lists the numerous experts that they consulted. But one other thing I would like to point out with respect to these medical records, and what does that mean that the defendant slit his wrist, okay? You have, at the time, a February 4th, 1991 report that's in the record at 6840. That's in the direct appeal record in the McCann case, Your Honors. I believe it's also in our post-conviction record. But this is Dr. Marin. There were Dr. Marin and Dr. Spray, who were two of the experts called by the state. And there is this comment. While in the Sarasota County Jail, the subject cut his wrist. He reveals some scars on his left wrist. With regard to why he had done so, the subject stated he lost his family and his girlfriend, and his girlfriend was seeing someone else. Thus, he has no reason to go on. He felt it was unfair that he was in his present legal predicament and felt he had no hope. Those records come in, this report comes in. So certainly the notion that it would support a statutory mitigator we believe is not well-founded, and the fact that it would be subject to impeachment on the records that the defense counsel had at the time when they made a tactical decision not to call Dr. Afield. I believe, let me just see if there's, in my assessment, Your Honors, this is classic second guessing of what trial counsel did, conducted extensive exploration of mental health defenses, mental health theories, used experts at the suppression hearing. They had a suppression hearing. The defense called 18 witness suppression of confession hearing. The defense called expert witnesses. They included bringing Dr. Afshi from California on the suppression of confession issue. They had included Dr. Afield. The state called Dr. Spray and Dr. Marin. So the defense was well aware of all of the ability to use experts, and made a concerted effort for the penalty phase to focus on humanizing this defendant and getting as much information as they could about his background. The mitigation specialist that has called in post-conviction, Ms. Hammock, is asked and admits that she could not find anybody that agreed with Dr. Afield. And so on the balance, there was much more harm that could come from calling Dr. Afield as well because of the admissions. At the time, at the beginning of the penalty phase, defense counsel broached the subject of presenting residual doubt. He acknowledged the contrary case law, that he knew residual doubt was not going to be an acceptable non-statutory mitigator, but preserved the record on that point. In response to that, when defense counsel said, well, I would like to present residual doubt, and ultimately did not do that and followed the court's ruling. If he had tried to pursue some convoluted theory of residual doubt, it certainly would have been lost by Dr. Afield, his own witness that CCR says now should have been called in light of the defendant's admissions to Dr. Afield. If the court has no further questions, I would ask this court to affirm the trial court's order denying post-conviction relief after evidentiary hearing. Thank you.
Quickly, the McCann case was 10-2 and White was 8-4. The White case was the one that led to the defendant's arrest. So as a result, the White case has a number of post-conviction claims that are focused very much on typical Fourth Amendment type issues regarding evidence and so forth. Those were either not granted an evidentiary hearing or weren't really a focus of the evidentiary. So in the structure of the two cases, there is a difference in that regard. The claims which were the focus of the evidentiary hearing, of course, dealt with the experts that we've already talked about. I want to talk about two things real quickly here. One is the notion that the defense counsel had an abundance of expert witnesses out there and chose not to call them. A lot of these names are people where the defense tried to and got the CV and had an initial consultation about rates, then went to the court, and the court said, no, you've had enough, so you're done. As far as Dr. Afield being a flip-flopper, the defense, I've got the argument in there, and there's some handwritten scrawled notes that might suggest that there was at least probably some casual conversation between defense counsel and Dr. Afield about the penalty phase. But all of the record points to the idea that Dr. Afield was brought in on the issue of insanity, and the defense kept the issue of insanity well past, right up until the trials began, and way past the point where Dr. Afield had said, look, I will testify about the mental condition of the defendant, but I will not go that far. And Dr. Afield said that on the stand. These were my clinical views of the defendant. That's what they were then. That's what they are now. They have not changed. If there are no further questions, I'd like to thank you all for your attention to the matter.
We thank you both for your arguments. We will now move to the second case on our docket. That case is Hampton versus the state of Florida.
It just shows how.
I understand.
Wow. He's never seen her, I think.
May it please the court, my name is Dbor Brookheimimer. I'm here representing Mr. Hampton in a death capital case. I have 5 issues. I plan to focus on issue 1 and briefly touch on issue 5. However, as always, this court has any questions on the other issues, I will be happy to address them. And the reason why I'm focusing on issue 1 is because this case falls under this court's very narrow exception of Lowry, where a juror misled the court on a direct question as to whether or not he or a family member had been accused of a crime. And when juror number 10 was asked this question directly by the trial court, he said, "Oh, yes, my sister had been involved, and no, there were no problems, no, I don't have any bias." And he completely ignored the fact that he had been arrested.
Well, at that point in time, what did he know?
He had been arrested
Well,
for
he
two
was at
counts.
some boat ramp someplace, and a police officer gave him something. It wasn't a notice to appear.
No, he was
No.
arrested.
Okay, he was taken into custody. He was released OR. There was no future court dates at that point in time.
No.
There was nothing. As far as he was concerned, it was over.
No.
Well, what
Arrest
did...
charges just don't disappear.
Well, I mean, do you and I
wait.
know that, but did he know it?
I believe he knew he was in trouble.
Typically, one gets booked in a county jail, and it's given a future court date. You don't just get released from jail OR without giving you a future court date or something to come back to.
I'm not exactly sure how misdemeanor courts work. I mean, obviously, felonies are a lot more serious. It took weeks for the state to get around to charging him.
It-
Was he given any kind of document that night?
I don't know if he was given a copy of the affidavit that the officer signed.
I'm a little confused to this extent. I thought that the argument that there was a misrepresentation by this juror was dropped by the defense lawyers because they realized that the questions asked did not actually, that there wasn't misrepresentation, and that the argument was more of a juror disqualification issue. Are you arguing misrepresentation, or are you arguing automatic disqualification, or both?
Both.
And am I incorrect that the defense lawyers, after they looked at the transcript, realized that there wasn't a misrepresentation?
No, I didn't. I see that they didn't really. They dropped it in the First Amendment, and when they amended their motion to interview, and they didn't exactly raise it in their motion for new trial. However, in response to the state claiming lack of due diligence, which is one of the De La Rosa requirements, the response is, did the attorney lack due diligence by not questioning the juror more to see if he was concealing this particular information? And the fact that the trial judge asked a direct question, got a response, which corresponded to that questionnaire that said, you, a family member or a friend, actually the questionnaire was broader. So the defense counsel would have had no reason to believe that he had to go further and question this juror further. In the Texas case,
Where I come from, that would have been 45 minutes worth of questioning of the jury. And you have a questionnaire where, have you ever been have you or any member of the immediate family or close friend been accused of a crime? Yes. I mean, there were no questions at all from the defense counsel.
There was one question.
From the judge, but not from the defense counsel.
And it was his sister. Now, in the Texas case this court cited to in Lowry when it said we agree, that particular Thomas case said when the trial court directly asked that question, the defense counsel need not go any further. He need not, it was a direct question, there was a direct response. And the juror, prospective juror right before number 10, or two jurors up, when she was asked that question, she said, yes, me and my granddaughter.
So how in the world, you know, what concerns me is that he was, as far as I can tell from this record, he was not given anything that night. He may have been stopped and talked to or arrested, as you say, by the police, and then he was let go. And he wasn't given anything that indicated in any way that there was going to be anything further on this. And so that's my concern. How did he at that point, before the filing of the complaint or the information, would know that he was now being accused of a crime?
Well, being arrested should be enough. And the question becomes is, what would a reasonable juror believe? That he's in trouble with this particular state attorney's office, and I used to do trial work.
How would he even know this is state attorney? I mean,
it's the
without
same
having
county.
Something.
It's the same county, Pinellas County.
Do we know that what the officer may have said to him? Did the officer say, you're going to have to answer to this later?
There was no evidentiary hearing because the juror was not, the judge denied access to that juror. So, I mean, we're asking for two possible remedies. One is interview the juror, go back.
Can we go back to this issue of preservation? The state says in their brief that in the motion for new trial, they only alleged the juror Deutsch was under prosecution and thus disqualified. That the argument that you were about misconduct was not preserved. You're just how was it preserved? I guess I want to just make sure about that.
When the state raises the fact that under De La Rosa you have to show due diligence, and they're claiming that
No, I'm asking you, how was it preserved before at trial? I mean, if nothing was raised, then
it's not a trial, it's post-trial because we didn't find out.
So how was it raised post-trial?
By asking for a chance to interview the juror, number 10, and by filing a motion for new trial.
But I thought the motion for new trial was based on that whether he was, quote, under prosecution, which is what...
And under prosecution...
Is that I mean, that's a statute under, that if he was under prosecution...
Right.
He'd be disqualified from serving as a juror. He wasn't under prosecution at the time that voir dire occurred, based on what Justice Quince and Justice Labarga are saying, correct? He wasn't under prosecution.
Well, I'm saying that the definition of under prosecution has not really been defined for 40.013.
So now we're switching. So there are two issues that you want us to look at. One is clearly preserved, which is whether he was under prosecution for under 40.013, and there we have a situation where somebody isn't given any papers, nothing is filed until after the voir dire. Correct?
We don't know if he wasn't giving any paperwork because we had no access to the juror.
So you're saying you need it because the issue of when these points in time occurred are controverted?
Well,
that you need
there's
a jury
no question
interview?
as to when he was arrested and when that arrest affidavit was filed. The question might become, did he feel like he was under arrest? Was he given paperwork? Do we know any of this?
Well,
no,
but that's
because we weren't given access.
Whether he feels like he's under prosecution, that couldn't be the standard.
It should be what a reasonable person would feel like when they've been arrested.
You know what's leading to the confusion is that you're arguing two different issues altogether.
At the same time.
Right, there's two different issues here.
Kind of like the questions.
One is, may I finish?
Right.
One is the issue whether under the statute this individual was under prosecution. Separate issue. totally different issue is De La Rosa. You agree?
Well, I would say
you don't
that
have to be under prosecution under De La Rosa standard.
in De La Rosa, the question becomes, in De La Rosa, the question is, was it disclosed? Was the disclosed information relevant? Pending charges.
Two different questions.
Right.
So could you please, in your responses to the bench, please try not to merge
Confuse the
those
two?
two, because one's talking, one of the justices is talking about prosecution, and you're talking about arrests and what somebody knows. So I really think we're doing a disservice to trying to get this point where it should be. So if you could address it in that fashion.
Well, under prosecution has never been defined in 40.013. We don't have set dates. The case of Tucker said that, well, it's most likely when the state files the information. However, by the time you get to the very end of Tucker, they said, well, even if this juror was under prosecution when she was given a citation on a traffic case, we have had an evidentiary hearing. We have found from this particular juror that she did not know that this was a criminal citation, that this was strictly a matter of fines, that this was from a long time ago. And so they were able, based on an evidentiary hearing of the juror, to determine that there was no prejudice. We didn't have that here.
Well, I guess, sticking with 40.013, I didn't think that prejudice had to be established. If somebody is under prosecution, they are disqualified. Is that correct?
Right. Well, they found that because this juror didn't think she was under prosecution, and it was a traffic citation where the state doesn't usually follow up on those things if fines are paid, they kind of got around from that exception in Lowry where no prejudice is involved.
But trying to go back to you agree with what Justice Lewis is saying, where this is two different things. One is a juror is disqualified where they're under a prosecution for any crime. All right. The other is, was there a misrepresentation or a failure to follow up on questions and then materiality? That's the De La Rosa.
De La Rosa, yes.
So what kind of a interpretation can be provided that would be beneficial to your client that he was under prosecution for any crime before or at the time of jury selection?
At the time the prospective juror at the time he had been arrested, number 10 was arrested. And
so you would say that although the statute says prosecution, that really prosecution means arrest. And
yes.
Isn't that just
kind of
contrary? Let me finish. Isn't that contrary to the plain language of that statute? It's if they said anybody who'd have been arrested for any crime could not serve, that would be we'd be in a different situation perhaps. Prosecution has a legal meaning, doesn't it?
It has several different legal meanings. In Brown, they used the definition given under statute of limitations. Tucker expressly rejected that definition. This court has, we don't have a definition under this section. What we do have is Lowry and the whole purpose.
So if this, given the same set of facts that this prospective juror had been arrested that night and no information or complaint was ever filed, would he still have been under prosecution at the time that he was serving on the jury?
Well, keep in mind, he was asked.
Excuse me?
Well, he was asked, have you been accused, as opposed to under prosecution, so...
Guess what? We're now
beyond
shifting to De La Rosa.
To De La Rosa.
So can you stick with
the
trying
under
to get
prosecution.
the prosecution?
And the reality is that...
Well, I mean, I think that's a simple question.
Right.
Would he have still been under prosecution if no information or complaint had ever been filed after that night?
I believe so. Because the whole purpose of Lowry is to prevent someone who may be trying to curry favor with the state from serving on a jury and getting a conviction of a defendant while he's attempting to curry favor with that same state.
The question Justice Quince is asking you is, let's say he got arrested on that particular day, taken into custody, released OR, nothing given to him. Okay, now, if the state had not filed the information whenever it did, what would have happened to that charge?
It eventually could be charged.
No. The question is, if a state had not filed information, ever, what would have happened to that charge?
We don't know, because there are pre-charge negotiations that happen frequently, especially in drug cases.
Well, your theory would lead to the response that he's under prosecution until the statute of limitation expires.
Yes.
I mean, that's what you're saying.
I mean, he has something to worry about until that statute of limitation goes away, which is a couple of years.
The rules of criminal procedure provide for methods of prosecution. And they say that prosecution for non-capital crimes shall be solely by indictment or information or a notice to appear. Those are the three ways to do it. There was no notice to appear, no information, and there was no, obviously no indictment in this particular case. So how can this be under prosecution if none of the methods to bring it under prosecution were not followed?
Because if we're trying to prevent a defendant, a prospective juror from sitting on another person's case from trying to curry favor,
so that's a
the
De La
state
Rosa
shouldn't
argument.
be allowed to manipulate that date, which they can.
You're going back to that De La Rosa argument as to whether or not this person should have revealed something like he was arrested and that kind of thing.
Right.
That he didn't.
Lowry
I'm talking about under prosecution.
Right.
Stick to that issue.
Yeah, Lowry dealt with 40.013. And, of course, in Lowry, the person was actually under prosecution.
There was no question in Lowry he was under prosecution.
Right. So now we're trying to deal with a definition which never really has been developed for 40.013.
What is wrong? What's legally wrong with the definition that has been suggested from the bench, the three ways that you're under prosecution? What is legally wrong with that holding? If this court should write, under prosecution, under this statute means, and then the three ways that you're prosecuted, what would be legally incorrect about that?
The idea that it doesn't include arrest.
Well, the statute, it doesn't say arrest, it says
no,
prosecution.
The rule of procedure doesn't include arrest. The statute just says under prosecution, and there's no definition.
I understand your position, which is, let's just take that this wasn't just an arrest for what turned out to be a pretty nothing situation, but he had been arrested for on a murder charge, and at that point, the state knows he's going to be serving on a jury, and nobody mentions, and the person doesn't mention that they're under arrest, and maybe they're in active negotiations. We certainly wouldn't want that person sitting on a jury. So now we go back to the question that you wanted to weave in,
which is the De La Rosa.
Is that but the statute would have to be expanded to say under arrest if the legislature felt that was a automatic disqualification. I just can't see how you get to it under this. So on the De La Rosa issue, you do not agree that the defense lawyers below dropped their De La Rosa argument after they looked at the transcript and looked at what was asked and answered as to whether there was a misrepresentation?
I believe, without an evidentiary hearing, which did not happen on either one of the motions. It's hard to know.
It's a simple question as to whether they
dropped the issue
it or they pursued it.
I believe that when you look at the disqualification under 40.013, things get a little blurry when you look at Lowry And then you look at the fact that they also used the De La Rosa test in Lowry.
Well, see, the same type of thing happens in civil litigation during jury selection. Jurors are asked, have you ever been involved in litigation? And when people think, what's litigation? That means a courtroom, a judge, lawyers, that kind of thing. Well, then they say no. Then later, we learn, well, they've been involved in a Social Security claim or a workers' compensation claim. They don't think of those things as litigation. They go before some kind of hearing officer. Here, once this juror was asked, have you been accused of a crime, and said yes, then defense lawyers, what they do in civil litigations, they come back up and say, well, you know, when we're talking about litigation, we're talking about all these things too. And then you see the hands going up. Here, they could have asked, when we're talking about accused of a crime, that means being taken into custody for anything, arrested for traffic infraction, not having a driver's license, something like that. See, that's what I'm talking about. They dropped the ball in not asking those questions, those follow-up questions.
And I would say that in the case in Lowry, in the Thomas case, which is Texas, the direct question was asked of the juror 10, and all he mentioned was his sister. And if a defense attorney were to go back to juror 10 and say, well, was there anything else? Have you ever been accused of a crime? Have you ever been arrested? There's probably a good reason why Thomas said that was good enough to stop with what the judge asked when he asked a direct question, is because you also have to worry about alienating the jurors that are sitting on your panel. You don't want to really accuse them of having just lied or misled the court.
Well, there's a way to handle that without accusing anybody of lying. You misunderstood. It encompasses this as well.
Right.
And a lot of jurists don't know exactly what, so I think they should have asked those follow-up questions.
Hindsight, maybe, yes. And as far as where the De La Rosa case comes in, I believe Justice Ann said in the concurring opinion, said that everything fell under De La Rosa when they were using the 40.013.
Well, let's just, I'm not sure we have a direct answer to the question that's still pending, and that's been...
The definition?
No, the question of, was it waived before the lawyers proceeded with the hearing below?
Well, they went under 40.013 and didn't give anything except to say, we believe this juror could have been legally disqualified. And then they signed their affidavit, and the focus was on the 10 days, the focus was when they discovered it, and the trial judge denied the interview because it was beyond the 10 days, because they didn't do due diligence. And whether or not due diligence in checking up on this juror during trial.
Well, you argued in the brief on page 43, you say because juror 10 concealed his pending criminal accusations, the 10-day rule is not applicable.
Correct.
And it was only because Mr. Hampton's counsel accidentally saw juror 10 at the criminal courthouse in October 2009 that suspicions were aroused and further investigation took place. But the first time you mentioned that is in the brief. That was not raised down below.
It was raised in the trial court's order, and the response to that in an amended motion, I believe for the motion to interview, was that they had done everything they could once they saw this juror showing up in the courthouse, and that they finally made the ultimate discovery on November 17th, and they filed their motion on November 19th. So, I mean, they were responding to that via the judge's order, saying that you didn't file within 10 days of the jury verdict. So, as far as whether or not the concept of the concealment, I believe, even though it's two separate issues, it becomes all part of the fact that, you know, did juror number 10 think he was in trouble? Why would he not reveal that information when it was a broad question? It wasn't a narrow question about prosecution.
The questionnaire asked accused of a crime.
And that's what the judge said orally.
And that's what the question, it was never asked, were you arrested for a crime? Have you ever been arrested for a crime? Is there a difference between arrested and accused of a crime?
I believe accused is just broad enough to encompass arrested.
You believe that, but isn't there, if he was asked the question, have you ever been arrested for a crime, and he didn't answer that, this would be a different case, wouldn't it?
Well, Tucker tried to kind of encompass all that because the juror W was given a citation in the parking lot in the middle of trial. And the question was, well, was she accused of a crime at that point? And Tucker never really does develop a firm definition, and when they get to the end, they say, well, even if she was accused of a crime at that point, or was under prosecution at that point, we don't care. We've already done our evidentiary hearing, and we find that that under this circumstance, it doesn't fall under Lowry. And Lowry's a very narrow exception, but it has a very important principle, which is the jurors shouldn't be allowed to sit on a jury in the same jurisdiction where they're facing criminal charges because of the fact that it looks like they're trying to curry favor. And footnote 5 in Tucker points out that why would they conceal that if they weren't trying to, if it didn't speak to the fact that there was some kind of bias or possible bias going on.
Counsel, you had wanted to reserve
a few minutes for issue 5?
8 minutes. You're down to
3.5.
3.5.
Okay. The only other thing would be that Evans, the Ring case, is still pending in the 11th Circuit. Briefs haven't been filed. Another case is similar. They haven't had oral argument, so I'm just giving you an update on that. And as far as the mitigation goes, I do believe that a new penalty phase is required because Dr. Berlin's expert testimony was erroneously rejected by the court without justification, without a reasonable basis. Thank you. I'll save the rest.
May it please the court again. Good morning, Your Honors. Again, Catherine Blanco for the Attorney General's Office representing the state of Florida. This is a direct appeal out of Pinellas County. The defense primary argument is their issue 1, their juror disqualification claim. As this court has pointed out this morning, there are actually 2 separate claims.
Can I ask just sort of a general question? Because I think that this is a difficult area. Let's assume it wasn't that he was arrested for loitering and he was arrested for murder. So he was arrested, but nothing else had happened. And the same exact jury questionnaire, have you ever been accused of a crime, or are you under prosecution? And that juror answered no to those, and the state knew, because it's the same jurisdiction, knew this was going on. Is there anything, is the argument that because accused doesn't mean arrested and prosecution is narrow, that until the state actually files charges that you could keep somebody and that juror would be acceptable to be on the jury, or would you see a problem in that scenario?
Your Honor, in the scenario that this court has just proposed, that would be an outright misrepresentation, where you say the juror answered no
to whether you've been
whether
accused.
he'd been accused.
Because they've just been, all they were arrested. Nothing else happened.
Well, in this particular case, we have our jury questionnaire where the juror checks yes.
So
when he's asked about that. But as to the issue, if you've got a prosecutor who knows.
So is accused and arrested the same? Is that the same?
The jury questionnaire, Your Honor, which is in Supplemental Volume 1, the question is on the jury questionnaire, have you or any member of your immediate family or any close friend, and then number 4 under that, been accused of a crime, question mark, and juror number 10 checks yes.
Okay, so then the judge asked the same question?
What the judge asks is actually a compound question, Your Honor. The judge's inquiry, it's in the record at Volume 5, Your Honor. And I believe we've set it out in our brief. What the judge is asking, he does make that general question to the panel, and he gets no response. It says, okay, have you or a family member been accused of a crime?
All right, so that's
And
the
so
same
that's, and then
isn't that the accused was what was in the jury questionnaire?
that's true. And so he asked that of everybody, and apparently no one is raising their hand, so he starts going individually. When it gets through that process of going down the line, the question then becomes, did the case get processed through the court system? Any dissatisfaction with the way it was processed? Can you set it aside?
But just go back to this, where this juror is asked then, have you ever, that's that question, and he says, yes, my sister. Doesn't he then omit that he hasn't just been, I mean, it's not like he could forget this, it just happened 2 weeks before, that he had been arrested 2 weeks before, or whatever it was. Isn't that an omission on his part?
Your Honor, it is certainly an incomplete answer, but the question, when it got to that juror, was the compound question, did your case get processed through the court system? Any dissatisfaction with the way they were processed? Can you set it aside?
Well, wait a minute.
By the time,
This,
so that is an ambiguity.
excuse me.
Yes, Your Honor.
This prospective juror apparently had already concealed, had not answered the question, has anyone been accused of a crime, when that general question was propounded to the entire panel?
No one answered that question, Your Honor.
Well, I mean,
That's
answered
true.
affirmatively.
No one.
So, well, we don't know about anybody else, but this individual sitting there and did not respond. Okay, that's where we are at that point.
That's where we are. No one, and there were other jurors that when they are asked, did your case get processed through the court system? And that is likely...
What prompted those questions if everyone was silent with regard to ever being accused of a crime?
Likely it was the fact that the trial court started going down the line and saying, are you satisfied? Was it processed through the court system?
I want to know what happened.
It is, Your Honor. There's no response to just that.
And so then the court just on its own asked, were you satisfied with the proceeding, when no one had ever admitted that they'd ever been involved in a proceeding? This is not making a lot of sense.
Well, Your Honor, it does when you see that the trial court does, and it's in Volume 5, it begins at page 4 of the record, Your Honor, where the trial court says, okay, now this is what I'm going to go on to. I'm going to move on to this topic. And so he does Row 1, have you or any member or a family member been accused of a crime? Mr. Lehman, you've already told us about your son, correct?
Okay, well, so somebody had disclosed
inquiry,
that. Someone had disclosed that then?
Yes.
Okay.
Absolutely. But, Your Honor, there is ambiguity in the question, and I believe that's why the defense counsel admitted below when they filed their motions. The defense motion are filed, Your Honor, in Volume 2 of the record. The original defense motion, and this is motion for juror interview, did allege, as paragraph 2, during voir dire, Stephen Deutsch failed to disclose to the defendant, despite direct questioning on the issue, that he was currently under prosecution by the same office that was prosecuting the defense case. The defense then files an amended motion deleting that entirely.
Well, we know because he wasn't under prosecution, but what you were, in response to Justice Lewis, he was asked directly, have you or any member of your family been accused of a crime? He says, yes, my sister. I mean, here's my question. This may not meet the rest of the De La Rosa prongs, but we've got a death case here. And we're already setting this up by the questions that are being asked, that these lawyers maybe were not as, maybe should have followed up, maybe should have asked a question. They didn't do it. So now, isn't it better that we have a jury interview to kind of get this out, see if, it's such a small, if it was murder, we'd be sitting, and I think you'd be saying, we better get, you better look at this and give another shot at this. But this is sort of a nothing crime. It may be a nothing issue. And it's maybe very likely that it would not have led to any decision to strike this juror. But we'll know it now rather than 5 years from now.
Your Honor, in this respect, it's very similar to the Ray Lamar Johnston case, which was sent back. It was affirmed on direct appeal on a juror disqualification based on a claim of juror nondisclosure. And when the case went back, there was, as there always is, a claim of ineffective assistance of trial counsel where this issue was developed more fully. Would the juror nondisclosure have caused the defense to exercise a peremptory challenge? Would have caused them not to have wanted this juror? And so to the extent that's what is concerning, Your Honor, I would believe that perhaps the more appropriate vehicle is not to remand for a new trial, a first-degree murder trial on a misdemeanor.
I'm not suggesting a new trial. I'm suggesting, I thought they asked for a juror interview.
They asked for a juror interview,
That's
and
not,
we know.
and it very may likely be that it doesn't meet the other standards. But there is not, we don't want in death cases to have jurors think that they can answer questions partly. This is it's a life and death matter. Now, again, in this case, he was arrested, and it wasn't, if this was a year before, but what's the time frame between when he was arrested for this and when the voir dire occurred?
His arrest was the first week of June, Your Honor. The voir dire was the third week of June.
So this isn't like, I forgot that I had just been arrested. And it's really the idea, although I appreciate that he's not under prosecution, it's not as if he had some expectation, he had an expectation this was going to go away. What was he? It was found he possessed marijuana. Is that what?
No, it was actually it was a loitering and prowling arrest, and he had a pipe that he said that he had used to smoke marijuana. So it's a possession of paraphernalia, first-degree misdemeanor.
Something that I'd want to know as a lawyer. Maybe I'd want this guy on my jury. I might like
the
that.
Defense.
Okay,
but looking at this particular juror, you've got a 25-year-old juror who's a former baseball player out of high school and unemployed now, and he may be very desirable.
He might be, but you need to know all the facts to decide whether it is. And he didn't answer a question that was asked. I don't know what is incomplete about or misleading about the question that was asked to him.
Your Honor, I'm not saying that the question itself was misleading. I'm saying that it was a compound question that the defense recognizes was not a direct question to him. Or the trial attorney. That was the trial attorney's perception.
The first question was, has anyone been accused of a crime? What's compound about that?
That was to the whole panel, and then as it distilled down the aisle.
That's exactly what happened in De La Rosa and some of the others. Questions to the entire panel, and individuals just sit there, do not disclose it. They go through, and others discuss what happens with regard to their lives, and that, yes, I've had these cases and those things, and the juror just sits there not disclosing anything. And a non-disclosure is no different than a false disclosure when the question is asked.
Then when you evaluate it under De La Rosa, Your Honor, you look at the three prongs of De La Rosa.
Exactly.
And the first one is the information must be relevant and material. We have no allegation by the defense in any of their motion that they would have exercised any challenge to this juror.
Okay, now we're going to the substance of a De La Rosa claim, and you may be right on that. But then the question comes up and has been posited to you. Why would you not need to know the circumstances of the event before you can do the De La Rosa, a proper De La Rosa inquiry?
Your Honor, I would I would actually refer this court back to Ray Lamar Johnson, both in direct appeal and in post-conviction. You know what the answer to that is. Had you been arrested on June 6th? We know he was arrested.
Okay.
We don't dispute
does the
that.
record, okay, and the record discloses what he was
Yes,
arrested for?
it does.
And so you're saying that the record is complete without a further inquiry with regard to this juror.
Exactly.
And the facts are there, and De La Rosa is decided in your favor. That's your argument then.
Absolutely. We know he was arrested. We're not contesting that.
So are you then arguing that a mere arrest is not being accused of a crime? I mean, that seems to me to be your logical extension, is the fact that he was arrested doesn't translate into he has been accused of a crime.
No, Your Honor, and let me clarify. And I believe in response to Justice Lewis was where you have what you need to know what you would find out, and you would find out that he was arrested. That doesn't mean that he was not accused of a crime.
So what's he?
That's a separate inquiry.
Are you conceding that he was accused of a crime at the time that he was questioned in voir dire?
I'm conceding that he had said yes on his questionnaire as to the accused of a crime. I'm conceding that he had been arrested on June the 6th, and I am arguing that that did not disqualify him from jury service because he was not under prosecution. And I need to split the issues again because I don't want to risk.
I'm trying to understand what happened. I will review the transcript, but there's the general question to the panel, and you say there's no response to that. But then there's the follow-up question to certain members of the panel. Is that correct?
That's correct, Your Honor.
Well, there's some reason that there was a follow-up to certain members of the panel, right? What am I missing?
I believe the court just went down the row.
Okay,
that's my reading. There's the general, this is a topic I'm going to get into, and then going down the row. And as they go down the row, the question then distills into the compound. Any dissatisfaction with the way it was processed? Did it get processed through the system?
Well,
Can you set it aside?
But we would assume from that the court did not understand that their silence meant that they all said no to the general question.
That's true. I think that's fair. I mean, the court
Otherwise, the court would not follow up in that way.
Yes, I agree, Your Honor.
Wow, this doesn't make any sense.
Well,
I've never been in a courtroom where a judge starts asking questions that are follow-ups in response to an affirmative response when there's no affirmative response. Just for laughs, let's go through and see how they like the proceeding, even though they've never been accused of a crime. Now, does that really make sense to a lawyer?
Well, Your Honor, this is my reading of the record, and it could be.
Well, the truth is.
I believe that and the way I read through the record, the way the questions went through, and then when the judge was going row by row.
The truth is this, is that things like whether you've been accused of a crime or something, people aren't like all, wanting to raise their hand and go, yeah, me. So I would assume that this judge, knowing that some of them had answered, he had better ask them individually. Now, it could be something else if we look at the record, but it's very, and Justice LaVarga knows this better as a trial lawyer and a trial judge, it's amazing how, someone doesn't answer anything, and then as soon as somebody hops up with something, everybody starts answering. And so it's a dynamic of jury selection. But he was, and I just want to make sure that in answer, though, to the general question to the jury, we're accused of a crime, you have said, and I think you answered to me and to Justice Lewis, that should have elicited a yes answer from this jury, from this juror.
Yes.
Okay.
Could you make the argument, or could you explain whether the issue concerning the misleading answer of the juror was preserved for appeal?
The issue with regard to the juror nondisclosure, as we call it, was not part of the motion for new trial. the motion for new trial relied on the disqualification issue, Your Honor. And so we have argued that now the motion for juror interview was different, but the motion for new trial, which is at page 304 of Volume 2, argued that the defendant did not receive a fair trial because no person who is under prosecution for any crime shall be qualified to serve as a juror, citing 40-100-013.
Did they raise it in the request for the juror interview, though?
They raised it in the request for the juror interview,
okay, so then
which
the
was
question is
denied.
going to be is whether that's sufficient preservation then.
Right.
Okay.
And we have argued that the motion for new trial did not preserve that issue. It was raised in the motion for juror interview, which was denied as untimely. With respect to the motion for new trial, the trial court denied.
I'm sorry. That was the basis of the denial was based on untimeliness, not on the merits.
The denial was based on untimeliness because the guilt phase ended on June 25th. The defense counsel saw this juror in August and October, and it was not until November that the motion for juror interview. So even if you say, okay, you don't have to, we'll give you some wiggle room here. You don't have to follow the 10-day rule. Well, how about in August? Well, no, we'll give you beyond August. Well, how about October? Well, we'll give you beyond October. You don't have that motion filed until November 19th. So the trial court on the motion for juror interviews denies it as untimely.
Well, what happened to I thought there was an amended motion for a jury interview, and in that motion, they no longer talked about the juror concealing the fact of an arrest.
That's true. The original motion for juror interview referred to the despite direct questioning. That's at page 250. The first amended motion for juror interview drops that allegation altogether. So we believe that it is.
Didn't they abandon it?
They have abandoned it.
When I asked the question that I asked you, why didn't you point that out?
I'm sorry, Your Honor. I should have. I apologize to the court. The motion for new trial did not raise it. The original motion for juror interview did raise it.
So it's not preserved.
But it was abandoned.
Okay.
So my
which
apologies.
was probably the first
my
question
apologies.
I asked Ms. Brookheimimer, because when I read this, I said not pursuing misrepresentation, only under prosecution argument. Your argument here, and it seems like a strong one, is it wasn't preserved below. It was either wasn't in the motion for new trial, and then it was abandoned in the motion for juror interview.
That is, Your Honor. And I should have referred to that originally in Justice Kennedy. I sincerely apologize to the court. It certainly was not in the new trial, and it was originally raised but then abandoned, and it has been waived. And so to the extent there's any inquiry of trial counsel on this type of an issue, that would be appropriate certainly for a claim in post-conviction with respect to...
And it would be true in a post-conviction claim, just so and that maybe it doesn't matter or it should matter, you would have to show that there would have to be a showing this juror was biased.
You would have to show actual bias, then you get into the Caratelli standard and Lugo and Caratelli. And again, I'm trying to keep the issue separate as to the under prosecution. The trial court denied the motion for new trial, finding that the juror was not under prosecution at the time of trial. The trial court relies on Tucker and also relies on Section 775.15, and also makes the finding that the defense failed to assert or allege any actual bias. And what's conspicuous in these motions is none of them allege that the defense would have exercised a peremptory challenge. And they did have 5 peremptories left, or even a cause challenge. A cause challenge would not have flown because the juror was not statutorily disqualified. And so, again, with respect to the juror interview, we know, and it is in the record, Your Honor, we do have the arrest report so that we know that the defendant, the date that the juror was ROR'd. Any suggestion that somehow this case should be reversed on direct appeal, we believe be highly unsupported on the face of this record, where there has been no allegation that the defense would have exercised any type of challenge to this juror that it was time barred, their motion for new trial, and also their amended motion that did in fact abandon a claim. If there are no further questions, I would ask this court to affirm the judgment and sentence.
May it please the court. Defense counsel's motion for new trial and motion to interview were very limiting. Where the first time it's brought up about the concealment after the amendment takes it out is in the state's response. It says that finally the defense has the burden of establishing that he was prejudiced and he didn't inquire.
Well, you know, I don't know how you preserve a claim by something the state happens to say. I mean, sometimes the state says things they shouldn't say. Sometimes they fail to say things they should say. And that does not make your claim for purposes of preservation, does it?
Well, it was then addressed in the court's order denying the motion for new trial.
Again.
Well, if the idea is that the court wasn't aware of the issue, it was. It was addressed by the trial court. And the trial court said that the defendant didn't show any prejudice by making a tactical decision. I'm kind of that response now because it's here, it's present, we have it. And the fact that there was no evidentiary hearing either of juror number 10 or even of this motion itself to further go into this response, you know, to the state's response and to the judge's conclusions. I can't say, I'm not, obviously whether or not trial counsel waived it is for another day, but I don't believe it wasn't before the court. I don't believe the issue was not addressed. I believe it was all there. And the fact is that whether or not you all interpret 40.013 to include the accusation, or if you use De La Rosa alone to find prejudice, I believe at the very minimum, as in Tucker, the juror should have been interviewed. So
how do you respond to the argument made that this particular juror became under suspicion when he was observed in the courthouse by one of the defense lawyers in August or October? When it was not
twice. It was kind of a cumulative thing.
Right.
They see him in August.
But it was not until November 19 that they got around to filing the motion, well beyond the 10 days after they had the suspicion.
And that's why I'm saying the 10 days only applies to after the jury verdict. Now we're not dealing with the 10-day limitation. We're dealing with what would probably be reasonable. And these two lawyers got together. The one brings up the fact that he keeps seeing the same juror, and they investigate and they discover it, and within 2 days of them getting together. Keep in mind, this happened in November. Mr. Hampton wasn't sentenced for several more months, in February, I believe. So is there some, I mean, we're not talking about something that happened 2 years later. We're also talking about the fact that this was discovered accidentally, which kind of gets us back to the concealed part. Now, would these lawyers have struck this particular juror? Again, we're dealing with the death case. Had they known?
Couldn't it have been that the lawyers made a tactical decision? We have somebody that's in the criminal justice system, and let's keep him there because he will probably be biased in favor of the defendant. That could have been a tactical decision. Well, but they wait until after he was the guilt phase to bring this up. I mean,
they didn't know they thought it was his sister he was talking about. They didn't discover the affidavit.
Didn't he check in the box that he had been accused? Yes.
No, you or an immediate family member or friend.
That was the judge's question. Wasn't it?
No. That's the questionnaire. The questionnaire includes all three. The judge only asked about two.
Okay.
So the judge's questionnaire was you or a family member. The questionnaire itself, which is, I believe, at 315 or something, says, have you or an immediate family member or a close friend been accused of a crime?
And he answered yes.
And he says yes, but he doesn't circle.
So that's all encompassing, is it not?
It's all encompassing. So when he responds and says, my sister.
So couldn't have made a tactical decision? Well,
We're not going to ask
friends
any
or
more?
his sister had been involved in the system, therefore he would probably be biased against the
Yes,
state?
but I think the question becomes whether or not there would have had a different change of heart if they'd known it was him who was actually facing the accusation.
They should have followed up with that. They made a tactical decision not to follow up on that.
They made a decision that was based on a direct question from the judge.
Okay.
Thank you.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All right.
So sick of reading this case for the last week. Yeah, what did you wear? You look like
Supreme Court of Florida is now in session. Please be seated.
We now take up the third case on our docket, Winslow versus the School Board of Alachua County.
May it please the court, my name is Terry Kahn, and I represent the appellant, plaintiff below, Julie Winslow, who was the mother of the student involved, Tiffany Chansey. There are just a few key facts that are important to keep in mind when addressing the issues raised in this case. This injury occurred at a bus stop. That's the most important fact. The bus stop was selected and designated by the School Board of Alachua County, and it was designed by the School Board of Alachua County. The design that the school board chose was to have a bus stop that had gathering areas for children on both the north and the south side of the road. The reason for that is that this was a main municipal artery, and there were no crosswalks or intersections anywhere in the area, so there was no safe way to cross the street other than by the temporary, so to speak, traffic control that would be put in place by a stopped school bus.
But as we start analyzing bus stops, certainly, I mean, I think the second question has already been answered by the Escambia County case in our court with regard to whether it's a planning level. But with regard to the duty that we get into, it seems to me that there is no school bus stop in the entire state of Florida that students probably don't have to cross a street somewhere. So how does this is not like it's something that's hidden or students are pushed out, have to stand out in the roadway like the Surratt case. This is the case where it's on each side and somebody has to cross the street to get to it. Help me understand why this case is different from all those where anybody that lives to the south is going to have to cross the street to get up to this bus stop somewhere.
It's different because of a couple of matters. First, the factual differences are it's a main municipal artery, and there is no corner, there's no crosswalk, there's no light, there's no way to cross the street other than by jaywalking. And jaywalking in most towns is punishable.
Now, they had a bifurcated bus stop, right? One on the north side and one on the south side. The purpose of that, they did that because they recognized it was a busy thoroughfare.
Correct, Your Honor.
So the students will stay on one side of the street until the bus came. The bus comes, they put out the signs, that's when they cross.
Correct.
Now, apparently, this student crossed the street before the bus came, went to the other side, to the other side of the bifurcated bus stop, and then proceeded to walk back across the street. And she was hit by a car.
Correct, Your Honor.
How can I've been struggling with this to try to ascertain how this is different. If there no bus stop was there, she would cross the street. You can't walk into a car and say.
I'm sorry, Your Honor, I didn't hear that last.
I was trying to determine what is different about this than if there was no bus stop. She just walked into a car, which is what she did. There's no allegation that there was overgrowth that caused them to stand in the street. She actually stepped into the oncoming traffic.
Correct, Your Honor.
And was hit.
Correct.
And how does the school board become an insurer of that kind of conduct?
The school board is not an insurer of that kind of conduct. What the school board did was the school board selected a site.
They did. That's the plan.
They selected a design. We don't challenge either the site or the design. What the school board did in order to implement the design was they enacted boarding procedures and a safety boarding rule. And in order to make this bus stop safe for the students, which is the highest duty of the school board, they put a rule in place that said you shall wait at your south gathering area until the bus stops, until it turns on its lights, until it puts out its stop sign, until you get the all clear sign from the driver.
In this case, just in terms of trying to get whether we're dealing with a legal cause issue, the duty, you're saying they were negligent in the way they operated it, and they didn't communicate or enforce their rules. That's
exactly, Your Honor.
But here, the facts is in the light most favorable to you. The bus had the bus come yet?
No, Your Honor.
All right. So we now have, and it's the north side of the street that the students are supposed to get on the bus from, the north?
Yes, Your Honor.
And she was on the north side.
She had crossed from the south side to the north side. If she had never left the south side until the bus arrived, this accident never happens.
But she went to the north side.
Correct.
But then she was going back to the south side to see a friend?
Correct.
And then she, as she said, before the bus comes, she's going back, and so what I'm trying to see here is that where is the legal cause between their negligent operation of the bus stop and this accident? And are you saying that if she knew that she wasn't, you're saying somehow she didn't know she's not supposed to cross the street in the middle of busy traffic?
Absolutely. That's pled in the complaint, Your Honor.
But isn't that, I mean, that would be, how is that, where does the school board have control of the student at that time, I guess?
The school board has control of the students because the school board has the authority to enact the school safety boarding rule. And they did enact the safety boarding rule, and they have an opportunity to communicate, monitor, and enforce that rule on an absolutely daily basis.
Well, but doesn't your theory really entail the obligation of the school board, if they're going to meet the duty you say they have, to put monitors, people, at every bus stop to make sure the kids are behaving and they're not running out and playing into traffic or doing other things that could result in an injury?
Absolutely not, Your Honor.
Well, I don't know how anybody can control what kids at a bus stop are doing if somebody decides they're going to run out into the road.
We're talking about a specific allegation, a specific rule. And there is absolutely no doubt from a factual basis that if that rule had been communicated, monitored, and enforced, this accident never would have happened because it is specifically pled, and we're at the pleading stage, that she didn't know the rule.
Excuse me. What time of year was this? School just started?
This was the very last day of school.
The end of school. So
Yes,
she'd
sir.
been at this bus stop for how many years?
I think she'd only been at the bus stop for 1 year.
1 year, but it was the whole year.
Exactly, Your
And
Honor.
the traffic was the same the whole year.
Exactly, Your Honor.
All right. And this was hidden from her.
No, but he said the traffic was not hidden from her. Of course not, Your Honor. What was never communicated to her was what the rule was. And in fact, she was encouraged to believe that that rule didn't exist because the school bus driver never told her. And
Even if
throughout
that was
the year...
case, even if that's the case, it seems to me that here, when she's on the south side of the
Yes.
street,
Yes,
and
Your
that's
Honor.
where her bus stopped, she had already crossed over to the north. If it wasn't communicated to her that she wasn't supposed to go over to the north, she had already done that safely. So,
Correct.
Take me from there as to how the school board has now done something that they were not supposed to do.
The whole purpose of the rule is to provide safety by preventing children from crossing the road other than when the school bus is there, allowing them to do it safely. She never would have been in a position to be crossing back to the south side if she'd stayed at the south side to begin with. The purpose of the rule is to allow students that are on the south side of the street to be able to board a bus that only makes one stop only on the north side of the street.
But I guess so the stop is the north side.
Yes, Your Honor.
She already went over the north side.
Yes, Your Honor.
So she's going to the south side to see her friends.
Yes, Your Honor.
And then she's struck when she's walking out again to the north side.
Yes.
I guess, is this not, let's just assume there's a duty that to have communicated the rules. I don't see where the legally where the legal cause is for this particular accident, even in the light most favorable to you.
The legal causation has to deal with foreseeability. And if you start with the purpose of the rule is to keep kids from crossing the street unless the school bus is there. It is certainly foreseeable that a student that crosses when the school bus is not there might cross back to speak to a friend because they forgot a book, because they saw something that interested them, for any number of reasons. It's completely foreseeable that somebody may be crossing in both directions.
I look at it in terms of duty. You know, it makes sense to me, your argument that if you're talking about duty of the school board, that a duty may exist where a student may safely board the bus. But here, I'm not sure that duty extends to a student who's crossing a road to meet a friend, where it seems like those are different obligations, because the student had safely crossed, as Justice Quince was saying. She was there, and she had made it across. Had she been harmed while crossing there, I think your argument would make more sense. You obviously don't control the facts of your case, but it's difficult for me to understand from a duty perspective where the school board obligation lies to a student who is safely at a bus stop and then goes across a road to meet a friend.
The duty stems from the fact that they have the authority to enact the rules. They did enact the rule. They didn't communicate it or monitor it. So, and that's operational. I think everybody agrees with that. The problem that the court seems to be having, I'm sorry, Your Honor.
And we know, and you've alleged in your complaint that this was not communicated to them, that they were supposed to stay on whatever side of the street
Yes, Your Honor.
that they lived on. And what do you, I mean, did you just make that allegation, or do you have facts to support that?
Well, I have facts to support that.
But I mean, in the complaint, or...
Yeah, there are facts alleged in the complaint to support that, and those are made in good faith. We intend to prove them. We will prove them.
Was this that you were dismissed in a motion to dismiss?
Yes, Your Honor.
For summary judgment?
This is a motion to dismiss, not a summary judgment.
So factual findings were made in a motion to dismiss?
I'm sorry?
Judge? Were there factual findings, I guess, made?
There weren't really any factual findings made in the order granting the motion to dismiss, other than that Actually, it was based on this physical custody concept. As I read it, was the trial judge said that because the school board didn't have physical custody, they had no duty.
Well, and looking at the actual opinion, which has no, the only facts it has is that she walked into traffic at a school bus stop. That's what they said. That's what the First District says.
Yes,
right?
Your Honor.
And it says because the school board did not have control over this student at the time of the accident, the school board had no duty to the student.
Correct.
So it's really, we're sort of talking past that, which is they don't necessarily have had to have control at that precise moment if they negligently carried out their operational duties. That's
yes.
where maybe the problem in that broad statement is. In the First District opinion?
Yes, Your Honor.
But if we got back into it, the fact is that there's still the bus wasn't there, and the issue of the control goes to where is their duty at that point in time to this student, and this goes back really to what Justice Polson says, where is their duty to control over this student at the time? Where is the duty over this student that would require them or allow them to be able to control the child's actions?
Well, they control the child's actions by enacting the rule and by monitoring the rule and by enforcing the rule. And as I said, if the child had never left the south side of the road, the accident never happens.
But the problem is this. Who, as a practical matter, is going to do that at a bus stop unless we would impose an obligation on school boards to have a monitor at every school board? Now, you mentioned, I think your answer to that is the bus driver.
Correct, Your Honor.
The bus driver had failed to do certain things. I've got questions about that also. The bus driver's responsibility is to drive that bus safely and to make sure that the conduct on the bus is appropriate and that things aren't going on the bus that shouldn't be going on. But how can we expect a school bus driver to know where the kids came from who happened to be at the one side of the road as opposed to the other side of the road? I mean, how in the world would the bus driver know that? How in the world can we expect the bus driver who's got this responsibility to drive this bus to be carrying out the kind of tasks that you would seem to impose on the bus driver? I think it would be physically impossible for the bus driver to do it, and it just seems to me to be an unreasonable expectation. Why am I wrong?
You're wrong because we've actually taken sworn statements from the bus driver and from the people at the school board. The bus driver admitted she knew where everybody lives. It's real easy to figure out how the bus driver knows this, Your Honor, because when she drops them off at the end of the day, she drops them off on the south side. The ones that go to the north side cross right in front of her bus and go to the north side. This is the last day of the school year. She's seen this now for 200 days. She knows exactly which side of the road the kids live on.
But she's not there. I mean, the problem is, if this was a case where the school bus arrived, and because it was the last day, maybe the school bus driver forgot to put out the flashing lights and the stop signs.
Correct.
We would have I think everybody would agree, we have a whole different case because we've got now, we've got a negligent operation by failing to deploy the stop signs and the lights, correct? But what is that school board driver to do when this happens before the school bus arrives?
The problem was that the school bus driver didn't do her job for the preceding 199 days. She knows what side of the street the kids live on. She sees that they're all at the north gathering area when the bus stops. She should say, you live on the south side. You're not supposed to cross until my bus stops and I give you the all clear signal. And by the way, the school board admits that that is one of the duties that the bus driver is charged with, is to communicate to the students how they're supposed to board the bus and also to give them the all clear signal. That's what the school bus driver is trained to do. That's what she's supposed to do. And so
there's no issue here about an
duties.
all clear signal.
Pardon?
There's no issue here about all clear. since the bus wasn't there.
Well, the issue is that she is encouraging the students to disregard a rule by failing to communicate.
By her acquiescence.
Exactly.
But isn't there a problem, and you've got some particular facts with this particular person, but you're asking us to speak in terms of a duty of the school board. And it just seems to me that that's a very broad duty that would impose unreasonable obligations, when the fact of the matter is there's a duty here for the parents to make sure that when their parents their children go to the bus stop, that they know how to get there and how they should be behaving also. There's not just one side to this. But we have eaten into your rebuttal time here.
I understand. If I could just respond very briefly, and then I'll say the rest. Whether the parents or the child were comparatively negligent is not before the court. All we ask is a chance to have our day in court, and our complaint was dismissed before we could do that. But this would not put any burden on the school board at all, because the school board admits the bus driver has these duties, the bus driver has the knowledge, the bus driver dropped the ball. And if the bus driver hadn't dropped the ball, there would be one less brain-damaged child today in the state of Florida. Thank you, Your Honor.
Thank you. And I will give you an additional minute.
Thank you, Your Honor.
May it please the Court. My name is David Delaney of the Del Graham Law Firm, and I have the privilege of representing the School Board of Alachua County, the respondent in this matter. Your Honors, the question in this case, I think we've all alluded to, is who is responsible for this student prior to the arrival of the bus. And that question has been answered uniformly and repeatedly since at least this Court's decision in the Harrison versus Escambia County case.
Let's go back, because I disagree with your statement. The conclusion you're getting to may be correct. But in Harrison, I mean, the Court very specifically said they had not reached. They were walking toward the bus stop.
Sure.
And the courts have traditionally drawn a distinction between students on their way, saying there's no duty at all for those. But once they get to the bus stop, it's a different story. And as I've gone through each one of these, and I've underlined, where it is, and they fall into those categories like surette, overgrowth, made the kids stand out in the roadway, and they were hit. And I don't see any of that or anything like that in this case. But I think we have to also be careful not to paint with such a broad brush where these duties are, because I do think that the case law in Florida is separated on the way to the bus stop and being actually at the bus stop.
Well, Your Honor, it's a distinction without a difference, because Harrison tells us that physical custody is the source of that duty, and that means the school official is there and able to supervise. Surette is factually distinct, and I think that Harrison and the Francis case just turned on the actual circumstances. I don't think the outcome would have been any different if the student had been waiting at the bus stop, which is the situation we have here. Keep in mind, Surette's a 1971 accident. It's decided before the commercial carrier analysis, before the current sovereign immunity analysis
well,
existed.
That gets into the trap issue that's discussed. That's what raises that. But
Sure.
We also have the Duco case, if I'm saying it correctly, out of Duval County.
Yes, Your Honor.
That one also was on the way to the bus stop, correct?
That's actually a student waiting at the bus stop.
That one was waiting?
But Dutco is a hidden trap case, Your Honor. It's only the student's second day at that bus stop in Dutco, as opposed to here, we've got a 14-year-old 8th grader who's less than 2 years away from driving herself around the state of Florida.
Here is, I guess, the question, and this is why we were, I think some of us thought we needed to take this case, is because the statement that they didn't have control over the student alone may not cover situations, and you may have other reasons, again, for being able to prevail in this case, that at the bus stop versus walking to the bus stop being, at least that starts to be closer to when the duty to the student is going to arise?
Perhaps if the bus stop is so overgrown with weeds that the students are forced to stand in the roadway. That's Surette.
So therefore, the idea that because they didn't have control at the time is not alone dispositive of duty.
It doesn't have to be. This court doesn't have to overrule Surette or Dutco to rule in favor of my client. Dutco's a hidden trap case. doesn't apply here.
But
There's no hidden trap.
But certainly what it does, I mean, it suggests that there is a duty there if there's a danger. And this idea of no control, I mean, if there was no control and you just don't have any liability at all, no responsibility. So that's what I'm saying is that and I'm concerned, as Justice Pariente, is that we paint this too broadly, that school boards, school entities that transport do have some obligations when the kids are at the stop.
The court doesn't have to reach that conclusion on these facts, and that's I think.
But isn't that? But the first district opinion reaches it on and saying no control. They reach it on that basis.
Sure, and I think that's the basis, the idea that if I had the opportunity to choose the language, I would have said that they didn't have physical custody
but that doesn't, again, that really doesn't answer the question, because I think you would agree that if the school bus had arrived and the school bus driver didn't put out the stop signs and then somebody was crossing and was run over, that there would be a negligent.
Absolutely.
Okay,
absolutely.
So
a duty would exist under those circumstances.
That is not then the idea that the control is when does it start? It doesn't start when they get on the bus. It may start, depending on the facts, while they're at the bus stop, depending on what is alleged as to their dereliction of obligation.
Perhaps I agree with what
I mean, again, they've created, just as, I mean, in the light most favorable to them, but they created a bus stop and there was no crosswalk and they know all that, but they envisioned that the kids would stay on either side of the street, correct?
Yes.
Until the bus driver comes along.
That's the allegation.
Okay. Now, I mean, what I think is sort of, and maybe I'm getting beyond on legal cause, this idea that she had safely actually come over to the side where she needed to be and then went back over and then struck when she's coming again. So I think that the issue of whether if they had been enforcing this rule, it would have made any difference, but maybe that can't be resolved at a pleading stage. What's your answer to that? Like, that is that they're saying that there was a rule and the rule was you stay on your side of the road until the bus comes, but that for the entire school year, that rule had never been enforced, and the school bus driver knew it, and everybody knew it. Does that change anything about their negligence or their duty?
Absolutely not, Your Honor, because really when you boil down what they want in that rule is you failed to tell me to stay out of traffic. That's an open and obvious condition in Florida for which no warning is required. That's under the sovereign immunity analysis as well as the duty analysis. And we know that from the Orlando case that we've cited to the court. That involved another middle school student who was struck while they stepped into traffic. That's the Payne case that we've cited to the court. This court's decision from 1984 where a high school student was jaywalking. The dangers associated with busy traffic is an open and obvious condition in Florida, which requires no warning whatsoever.
If she were heading to the north side where the bus stop is, you're saying it makes no difference. The same rule would apply even though she was in fact heading back to the south side in this case.
Sure. What's really going on here, Your Honor, is that school districts provide information to students. That's kind of their job, to educate them and to promote their health, safety, and welfare. Every instruction along those lines doesn't necessarily give rise to a cause of action. For instance, establishing a rule that says students should stand outside of the roadway and not jaywalk until the bus arrives is one of those situations where it's designed to promote the health of students but doesn't give rise to a cause of action because traffic is an open and obvious condition in Florida which requires no warning whatsoever. On the duty question that I think the court is perhaps struggling with a little bit, Your Honors, there is definitely an argument to be made that no duty at all exists towards students by a school district prior to it taking physical custody, prior to the bus arriving and starting to exert control over those students' behavior, because there's no supervision of what's happening with the students
at that time frame. At a certain level, I mean, you can't have, it seems to me, a bus stop knowing that you've got, say, a four-lane road with traffic whizzing by in all directions, and then say, oh, this is open, obvious traffic. Good luck, students, trying to make it across there, but you got to try to make it across there. But so you bifurcate the bus stop to do it on both sides, but all the time knowing that students are crossing the road all the time. The bus driver, as the plaintiff's lawyer said, knows this because they see it happen all year. I mean, at a certain level, with parents complaining, there does seem to be an operational issue there and a duty arise. I think what saves the board here is the student going back across the road and once safely there.
Well, Your Honor, the Florida legislature has said that there is a duty owed under those circumstances, and it's owed by the parent, because parents are responsible for their children prior to the arrival of the bus.
If where the bus stop is, so all the obligations on the function of the parent.
That's what 1006.10 says, and that's what the Florida Administrative Code provision that we've cited to the courts. They explicitly address this issue, that prior to the arrival of the bus, this is the parent's responsibility, and that's a common sense issue, Your Honors. Parents know their children best, and parents are and they know their own neighborhoods best, and parents are in the best position to assess the maturity level of their own child and the traffic conditions to exist, and decide if that child can safely wait at the bus stop.
There is a little bit of an outrageous, and I look at whatever there is. I mean, again, we talk a lot about parents' responsibility, but this is a middle school student, and and this is the problem maybe with commercial carrier, if a bus stop is placed in the middle of busy traffic, and then you've got the municipality that maybe should be putting up a traffic light, but there's no liability because that's a planning decision, or a crosswalk. And then the school board can't be responsible for having placed the bus stop in a dangerous area. We have then sovereign immunity because those are planning level decisions. So I think that's really the frustration for parents may be that the remedy is not with a lawsuit, but it's with trying to get the traffic change. But I still go back to the question, I guess, of, are you saying that because parents are also responsible, that the school board would have no duty under any circumstance at a bus stop before a bus arrives? That is the rule of law, and that's been enunciated in all these other cases?
No, this court doesn't need to reach a decision that's that broad, because really what happened in Winslow in the First District's decision is in complete accordance with Francis, as well as the Escambia case that was referenced earlier, the Harrison decision. Under the facts of this case, where the danger complained of is open and obvious, it's not a hidden trap like Dutco, where the car suddenly left the road and scattered children standing over in the grass. It's an open and obvious condition on a two-lane road, which alleged to have a 35-mile-per-hour speed limit. There's nothing unusual about this particular bus stop location than any other bus stop location in Florida. But the court doesn't have to overrule Surratt or Dutco to arrive at that conclusion, that under the facts of this particular circumstance, a duty was not owed, because the student voluntarily crossed the road and then crossed back to go talk to a friend. And because if there is any responsibility owed, it's coming from the parents. And that's the Florida Administrative Code provision that directly addresses this issue. We've cited that to the court. The Florida Administrative Code is promulgated by the Board of Education on the authority from the Florida legislature, and it says parents must make sure their students follow the rules at the bus stop, and it says, quote, parents must provide necessary supervision during times when the bus is not present. That's determinative of the outcome.
And that flows directly from the statutory provision, which recognizes the limitation on the school bus driver's control and authority. And only when the school bus driver is there. And so that's just kind of explaining the implications that are inherent in the statutory text itself.
And I understand that those two provisions, the statute and the administrative code, are inconvenient to the petitioners position, and perhaps there's been no response so far over the course of this appeal because there's not a legitimate response to that. But those should be determinative of the outcome. In 5 briefing opportunities, twice to the First District and 3 times before this Court, that statute and the code provision have not been addressed. So any response at this point should be deemed waived, and that should be the complete and total outcome of the case. There's an issue of fairness here, Your Honors. It's not fair to put the responsibility on this school district for supervising children prior to the bus arriving and prior to being able to exert any type of supervision of what's going on. There's been the suggestion that the bus driver knew because of the location of where the students were when the bus rolled up. A completely equal interpretation of those set of facts is the parents met their obligation to walk the students to the bus stop. They went down to whatever the nearest intersection was and walked them over to the bus stop themselves. Or the parents put them in a car and drove them there and dropped them off on the side of the road. All of those are unknown to a bus driver because they're not there on the scene. There's 3 separate arguments that we're presenting to the Court, just to be entirely clear. First, there's not express and direct conflict. This case is a much less compelling plaintiff's case than the Francis case was that we've cited to the Court, where there was a directive for that student to go across the street. And this Court considered Francis back in 2010 and did not conclude that there was express and direct conflict with any other statutory authority and declined to review it. In addition to our argument that there's no...
Did the Court at that time address the statement about control? To your recollection that no duty to the student, implying that you have to have some kind of physical control?
That is part of the reasoning in Francis. And Francis relied heavily on this Court's Harrison versus Escambia County case in reaching that conclusion.
But again, see, Harrison is one where they're walking to the bus stop. They're not there.
Sure. And this student in Francis was crossing the street, was actually...
To get to the bus stop.
Again, it's a bifurcated bus stop, just like we're talking about here. 2 stops on the same side of the road. And a school guidance counselor in the Francis case said, I want you to go cross the street and wait for your bus at this other stop. So they're acting at the direction of a specific school employee. And that wasn't sufficient enough under those facts to create a duty in this case. And it wasn't sufficient enough for this Court to want to take it up on review. And if Francis doesn't create conflict, then certainly this case shouldn't either. But in addition to the fact that we don't have conflict jurisdiction, there's not a duty that exists because there's no duty to warn of open and obvious conditions such as busy traffic. The statute tells us that there's no duty owed, as well as this administrative code, the Harrison pronouncement. But there's a third argument, and the petitioner must overcome each one of these arguments separately. Any one of them should determine the outcome, and my client should prevail. But the third argument is sovereign immunity. And that's, again, the string of cases that we've cited, that the dangers associated with crossing the street, jaywalking, busy traffic, are open and obvious, for which no warning is required whatsoever.
That's different than saying that it's a planning level decision?
Correct. Those are, I believe, decided on the operational level, Your Honor. And the question is, well, was there an operational duty present? And the answer to that is no, because there wasn't a hidden trap, because traffic is an open and obvious condition for which no operational level warning was required.
But you think the stronger, I mean, is that the stronger argument, sovereign immunity or duty?
They're all strong.
Good
They're
answer.
invincible, Your Honor. In addition to those points, Your Honor, there's some overarching principles that are really in play in this case, and that a finding in favor of the petitioner would do violence to this court's stare decisis on the concept of physical custody. The petitioner is trying to create a new duty that doesn't presently exist in Florida, that we're going to make schools responsible for student behavior when they're not physically present to oversee it, and also when they don't have the authority to control the behavior. And the outer limits of whatever that new duty is very hard to define. It's going to overburden this already strained court system in trying to figure out with a flood of new cases.
This seems to meet itself coming around, though, if you say that if there's a hidden danger, there is a duty to warn, even though there's no control. That, to me, says, well, the control is not the key factor here.
And that's why...
Because you wouldn't even have, I mean, there'd be no duty in those cases at all.
Sure, and the court does not have to go that far in this case to reach that conclusion. They could rule on lack of conflict or on sovereign immunity. That it's an open obvious.
Since they've given enough facts here that she walked into traffic and was struck by a motor vehicle, so there's no question that we're not dealing with a hidden danger or some other negligence in the maintenance of the school.
It's especially not hidden because parents complain repeatedly about this, right?
That's the allegation in the complaint. And again, that's the parent's responsibility to address and supervise their child and decide what's a safe enough condition for my child under those circumstances. And the Florida legislature has defined that duty for us in this set of circumstances, as well as the executive branch acting through the Board of Education. There's a separation of powers issue that brings up. And common sense. Parents are in the best position to know their own children, know their own neighborhoods. In conclusion, almost 30 years ago, we've had the decision, the guidance that a school district's obligation towards students is based on physical custody, their authority over the students, and their ability to supervise and see what's actually happening. Less than 2 years ago, this court declined to review the Francis case, reaffirming that same concept. In between, it's been written into the Florida statute. In addition to all of those reasons, this is an open and obvious condition for which no warning was required and would not have changed the outcome in this case. This student was not trapped by some hidden condition. She was going to talk to a friend. And for all those reasons, Your Honor, there's no conflict jurisdiction. This court should decline to review it. There's no duty under the circumstances. Sovereign immunity applies. And because the petitioner is unable to overcome each one of these arguments, this court should decline jurisdiction, or in the alternative, it should affirm the first district's ruling. Thank you.
Thank you. You've got a minute and a half of your time, and I'll give you an additional minute.
Thank you, Your Honor.
But since I'm doing that, could you address that statute and why that's not problematic for your position? Because you specifically focus on the responsibility of the bus driver, and that statute seems to cut against what your position is on what the bus driver was supposed to do.
The reason that is not determinative is this. The school board has the obligation to provide transportation. The school board in this case designed a bus stop, and it's not the same as Francis. Francis was two entirely separate bus stops. The bus stopped at the north side, it stopped at the south side, or east and west. It's completely different. In this case, the school board the school board created a zone of danger by requiring students to cross the street. The school board itself recognized that it was exposing the children to danger. The school board itself took steps to ameliorate that danger. What the school board is now arguing is, even though they recognize it, even though they took steps, even though they enacted these procedures, no matter how crummy a job they do at following through on their own procedures, they have no responsibility. That's essentially what they're arguing. All we're arguing is that having taken these steps, they have an obligation, an operational obligation to communicate, monitor, and enforce. It's not putting any burden.
You're telling me they had an obligation to communicate what? Don't walk in the street when the cars are coming?
No, they had a obligation to communicate to the students to stay on the south side until the bus stops and stops traffic.
So the bus stop is on the south side. She's on the south side. Then she crosses over and goes back. I mean,
the pole star of duty is foreseeability. It's certainly foreseeable, as I said previously, that if she crosses once, she may cross again. She might cross to the north side and forget she had her homework. She might cross to the north side and remember she needed a book. It's completely foreseeable that she could cross twice. And therefore, the duty, they violated their duty when they never bothered to communicate and monitor and enforce that rule, and that was a proximate cause of this accident.
So they're supposed to have somebody stationed there
Absolutely
every day to watch before the bus comes?
Absolutely not, Your Honor. It's absolutely not necessary. The school bus driver knows that those kids are crossing the street before the bus gets there, because every day when she arrives at the bus stop, they're standing on the north side of the street. There is absolutely no need. That's a straw man. That's a red herring. There's no need for anybody to monitor this bus stop. We're only asking that they do one thing. We're only asking that they clearly communicate, that they monitor, and that they enforce their own procedures, which they themselves recognize are necessary to make this a safe bus stop. It's purely operational. Thank you, Your Honor.
Okay, we thank you both for your arguments. We now move to the final case on today's docket, Williams versus the State of Florida.
May it please the court, Peggy
Wait just a
Natali.
minute.
I'm sorry.
Please proceed.
Thank you. I'm Peggy Natali. I represent petitioner Amos Williams. Mr. Williams was charged with attempted first-degree murder. He was convicted of attempted second-degree murder. On the jury instruction on the attempted voluntary manslaughter read, committed an act which was intended to cause the death of the victim and would have resulted in death except he didn't succeed. So the jury was instructed that in order to find for voluntary manslaughter, there had to be an intent to cause the death. In Montgomery, this court unanimously decided that it was error to instruct the jury that there was an intent to cause death in manslaughter. It's just a natural progression of this court's decision in Montgomery that the same logic should apply to the attempted manslaughter by act. 4 out of the 5 district courts of appeal have held that it's fundamental error to give this same instruction that was used in this case. It's fundamental error in this case because when the jury is not properly instructed on the next lower crime, it's impossible to determine if the jury, if properly instructed, would have found the defendant guilty of that next lesser included crime. And here, the instruction...
Would you describe the facts?
The facts.
Of this crime?
It was a stabbing, multiple stabbings, in the leg, the chest, I think the arm, the face. Over a period of a couple of hours, it seems like. He followed her outside, he drug her back inside, and then finally the police arrived. So anyways, fundamental error also because this court has decided in Reed that when something's pertinent or material to what the jury must consider in order to convict, it's fundamental. And in this case, the intent was a disputed element at trial. The defense argued there was no intent to kill. The prosecution obviously argued there was an intent to kill. Because the jury wasn't instructed properly on the attempted manslaughter, we don't know, we're not able to test, they weren't able to test really, if the verdict for attempted second-degree murder was the proper outcome that they wanted to. Obviously, they ruled out an intent to kill, or at least a premeditated intent to kill, because they didn't find him guilty of attempted first-degree murder. So the only option they had available to them, just like in Montgomery, was that where there was no intent, really was second-degree and possibly aggravated battery.
I mean, every other court, district court of appeal, other than the 4th District, has ruled the way you're advocating.
Yes, they have.
And I was trying to understand the reasoning of the court in this case about how Montgomery doesn't compel the same result. Could you address anything that you would say is a fallacy in their reasoning?
Well, the court, the 4th District seemed to say that the intent was to commit an act. They interpreted the way the jury instruction was, that it just said intent to commit an act, and that it didn't say it intended to cause the death. And I'm not sure how they arrived at that conclusion, because the average
we obviously,
juror...
when we adopted the original instruction, I mean, you know, again, it's unfortunate that the court may have contributed to these various errors, because I think everyone always knew that intent to kill wasn't going to be part of manslaughter. That some intentional act was required. So there, again, the issue here is, but they were given an instruction that that said intent to kill.
Yes, definitely.
Perhaps this is a friendly question, but it seems there's a principle that if the general crime, the completed crime, requires a specific intent, that logic follows that the attempted should also require specific intent.
Yes, and you found that in Gentry.
Gentry, 1983. And it seems to be the case here, so I don't follow the 4th District's reasoning and say, and there's a difference between a completed crime and attempt.
I didn't follow it either, honestly.
Well, like I said, it was a friendly question.
All right. If I could find the Williams, just a minute. What they said in Williams, and I'll just read it to you and you can make your own interpretation, was that an intent to kill, the error of instructing the jury that an intent to kill is an element of manslaughter does not exist when instructing the jury that the defendant committed an act which was intended to cause the death of the victim. Then they said, as the 2nd District explained, you cannot commit an unintentional act, and they cite Hall. Well, actually, later, the 2nd District came back and said to the 4th, no, you misinterpreted us in Hall because we found there was an intent to kill. So the 4th District also reasoned, this may explain why the Supreme Court has not amended the attempted manslaughter instruction, even though it's twice amended the manslaughter instruction, the attempted. She's saying the Supreme Court hasn't amended the attempted manslaughter, but has amended the manslaughter instruction. Well, we know that there's now a proposal before this, I think it's before the court, for an attempted manslaughter by act instruction, which would eliminate the intent to kill. So that was the 4th's reasoning in reaching the decision. And I think that at least part of that has been shown to be faulty reasoning. Are there any questions? If not, I'll save the rest for rebuttal. Thank you.
Good morning. My name is Melanie Dale Serber, and I'm here on behalf of the state. In this case, the 4th DCA certified 2 questions. The first one was, does the standard jury instruction on attempted manslaughter constitute fundamental error? I submit that the 4th DCA is correct, and the answer is no. The second question, is attempted manslaughter a viable offense in light of State v. Montgomery? And I also answer that question, yes, because Montgomery does not apply. We must look at this court's prior precedent. It's been cited in the briefs, but it hasn't been discussed yet. This court's 1983 case in State v. Taylor specifically talks about the crime of attempted manslaughter and how it's committed and what you need to prove. I would submit that that case talked about the requisite intent, not just the intent to do the act. It was the act in that case was a shooting. In this 1983, this court said in Taylor that showed an intent to kill for attempted manslaughter. So I think we need to look at that precedent that hasn't been discussed with respect to this instruction.
Well, didn't Montgomery clear that up?
Montgomery, my argument is, and this will get back to the specific versus the general intent that we were talking about in Gentry, Montgomery did clear it up for the completed offense. And while I understand the reasoning of Gentry, I would point to the language of Gentry, which specifically explained the rationale was that had a death occurred, the defendant could be prosecuted for second-degree murder. There is no good reason to reward the defendant simply because the death did not result. And I can take it further. there's no other crime that would have covered an attempted second-degree murder except for taking the rationale that there would be a reward for not having the crime. When you look at what happened in an attempted manslaughter case, if you make the jury instruction intent to commit the stabbing that may have resulted in the death, except it didn't happen, it's going to be nothing more than the aggravated battery instruction that was in fact given in this case, and the defense argued that it was an aggravated battery. That's the problem. The attempted manslaughter, in applying Montgomery to the attempted manslaughter, you will subsume that into an aggravated battery. And there's some issues with felony offenses when we get into that.
Let me just make sure I understand. You're saying that for attempted sexual battery, attempted manslaughter, that there has to be a intent to kill.
Yes.
Now, how is that different from attempted first-degree murder?
It doesn't rise to the level of culpability. It's not a premeditated design, and I think that's when we get into the discussion about the history of the levels of the offenses and the level of culpability. Attempted first-degree murder has a premeditated design with the intent to kill. But a premeditated design can be formed a moment before. It's a fully formed intent. So is somehow the intent for attempted manslaughter going to be, how is that going to be differentiated from the intent for attempted first-degree murder? I would submit exactly as it has always been differentiated by using the heat of passion example. It's the circumstances of the crime that define that intent, I think, the intent to kill, and how it becomes the premeditated design of an attempted first-degree murder case, where it's we'll just call it an attempted heat of passion case to distinguish the term manslaughter.
Attempted second-degree murder, isn't it?
Heat of passion?
Heat of passion.
Heat of passion has always been recognized as a voluntary manslaughter. Second degree is the depravity, the indifference, which I think is where we get lost. In second degree murder was specifically addressed in Gentry, specifically how it would reward the defendant.
Let me see if I can understand what you're actually arguing here. Are you actually saying that there is no attempted manslaughter?
If we apply Montgomery, and because the jury instruction would have to be something along the lines of the defendant intended the stabbing and it would have caused death, but it didn't, is really how it comes down in the most simplest terms. That's going to be nothing more than aggravated battery, which was given in this case, and I'll read those instructions as they were read, which is how I come to, it's a logical conclusion going through the instructions.
Is attempted manslaughter the same degree of crime as as aggravated battery?
That is exactly what I was going to get to next. Going through what the offense levels, starting at attempted first-degree murder, it's a first-degree felony. Attempted second-degree murder is a second-degree felony. Attempted manslaughter is a third-degree felony. And aggravated battery is a second-degree felony, which therein lies a problem, because using the Montgomery analysis to apply it to an attempted manslaughter instruction, that would be the detriment of defendants. They don't get the third-degree felony any longer.
But he was convicted of attempted second-degree murder, which is what degree of felony?
That would be a second-degree felony.
Okay. And then not attempted, but
aggravated battery.
Aggravated battery
would also be a second-degree felony.
Would be a second-degree felony. So you still end up with no next
exactly.
felony.
There
correct?
would be no instruction, because it would be the same instruction for two crimes. For attempted manslaughter and aggravated battery, the instructions, if you lay them side by side, for the attempts would be the same. So to the detriment of the defendant, without having the intent to kill heat of passion style manslaughter,
except the jury would be instructed with the attempted manslaughter that this is in fact a third degree felony, correct?
I don't believe that that was instructed in this case regarding the degrees of the felony. It's the lesser included crimes are instructed as attempted second-degree murder without defining the degree of the felony. It defines what attempted second-degree murder would be, and then there's to prove the crime of attempted voluntary manslaughter, and then aggravated battery.
He was charged with first-degree attempted
murder.
first-degree murder.
Attempted first-degree murder.
The next lesser included offenses are attempted second-degree murder and aggravated.
Not the way the verdict form reads. I understand. In putting them side by side, it's where I started thinking logically we have to think of the logical application of Montgomery to these cases. The jury is instructed in the order of attempted first degree, attempted second degree, and then attempted voluntary manslaughter or attempted manslaughter
by act. Which is the third degree.
Which is third degree. And then below, they are instructed on aggravated battery with a deadly weapon which could cause death or great bodily harm. Which is exactly, yes, which is second degree. I double checked the statutes to make sure before I came in here, that's how it breaks down. And it also, things may change when there's a firearm involved, but then it would just elevate aggravated battery and attempted manslaughter to the same degree of felony. They'd both be second-degree felonies.
In distinguishing ag battery from attempted manslaughter, I know they both end up being the same degree felony, and you say in this portion here, actually they're not the same degree felony.
No,
they're not. I take that back.
Have any of the other district courts of appeal, other than the fourth, addressed the issues you're talking about, that it's the same as aggravated battery?
No, it just, in looking at the facts of the case and frankly looking at the fundamental error analysis, that's how I came to, even if we applied Montgomery to this case, it would be almost impossible to be fundamental error because the very instruction that the defendant is saying he didn't get or should have gotten, he did get if Montgomery applies, because the aggravated battery instruction states exactly what Montgomery says. That's why I don't think Montgomery needs to be changed or overruled for this case or even looked at. This court just needs to look at its prior precedent. Now, there may be some inartful phrasing regarding the intent to kill and the intent to do the act in Taylor. Is your
argument the basis of the fourth ruling?
I think it is. The fourth did note the difference between the manslaughter completed crime and the attempted crime. And I recognize that Gentry exists regarding second-degree murder, but I think based on the rationale in Gentry that this court didn't want to reward a defendant by doing away with the crime. In this case, if we don't tailor the instruction to the actual crime that was committed, the defendant it's going to be to the detriment of the defendant in some cases where it's going to be a third-degree felony. There will be no attempted manslaughter if we apply Montgomery. It would be nothing more than aggravated battery, which is exactly
what the aggravated battery instruction that was given in this case.
To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. Amos Augustus Williams intentionally caused bodily harm to Samantha Lindsay. Amos Augustus Williams, in committing the battery, used a deadly weapon. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm, which is exactly what Montgomery would call for in an attempted manslaughter instruction.
Do you contend that any of the district courts of appeals opinions are wrong that have dealt with this issue?
To be frank, yes, in the sense that I don't know all the facts of all of them if there were aggravated battery instructions, so I don't know. If there were no aggravated battery instructions, I think there may be a problem with failing to instruct on the crime required to be instructed by Montgomery. So that may be why they're wrong if their facts allow for it. And I think that's why this case in particular is important, because we do have the jury instructions laid out. We do have an explanation of what these crimes are to determine how would Montgomery apply to cases, which is exactly what Montgomery itself called for. Montgomery didn't say every error is fundamental. It was fundamental in the case of Montgomery. So you have to look at each case to determine if it would be fundamental error in not giving a correct jury instruction. In this case, we got the correct instruction. So there is no, I would submit there is no error, not so much that it's not fundamental. It actually complied. It's just that, for lack of a better term, it's the label on the crime.
You think that the instruction that was given here, the attempted manslaughter, which talks about having an intent to kill, is a correct attempted manslaughter instruction?
Yes, Your Honor, I do, pursuant to this court's precedent in Taylor. As I pointed out, in Taylor, it's from 1983, that was also a gunshot case.
I'm still at a loss, however, how you can have the higher offense, manslaughter itself, not requiring an intent to kill, manslaughter by act, not requiring an intent to kill, but the attempted offense requiring an attempt to kill. If you could explain that to me, maybe I could.
I would actually point this court to Montgomery itself. In Montgomery, this court specifically stated that it could be inferred that there's an intent to kill. The intent to do the act would cover both types of voluntary manslaughter and involuntary manslaughter by act, the two types of manslaughter by act that have been recognized by this court for over 100 years. I mean, since 1899, this court has recognized there's two types of manslaughter by act, in a sense, for the best way to describe it. There's involuntary and voluntary. You at least have to have the intent to do the act, but you can infer an intent to kill. And I think when you look at Taylor, this court prior to Montgomery did say the only way to commit attempted manslaughter by act was to have an intent to kill. There is language that says there was an intent to do the act, but that language comes 2 paragraphs after this court said the doing of that act, it's inferred the intent to kill was there by shooting in point blank, that you proved the requisite intent to kill. And
but it certainly seems to me that, logically speaking, if manslaughter requires an act, then attempted manslaughter would certainly be an attempt to commit that act.
Well, I'm not saying that attempted manslaughter doesn't require the attempt to commit the act, but it has to require the intent to kill in order to be convicted of it. Otherwise, Montgomery effectively would abolish the crime of attempted manslaughter by act, because, again, logically going through the crimes as charged to the jury, it would be nothing more than an aggravated battery. And I can't imagine that that's the intent of Montgomery. It looks to me Montgomery covers both types of manslaughter by act, the intent to kill and the intent to do the act. You intended to do the act when you shot a gun or when you stabbed. I mean, in this case, we have a protracted crime of stabbing. Their child was in the house. The victim was pulled back in and stabbed again. I mean, this crime is nothing if it's not an attempted second-degree murder. But the jury in this case heard everything, and they heard a correct jury instruction on attempted manslaughter by act. It's the circumstances that really define what the intent is. I think just saying the words intent to kill don't necessarily raise it above the depravity. I think that's what got lost in Montgomery, because in Montgomery we're dealing with completed crimes. Now we're talking about an attempt, and attempts have to be looked at differently. And I do recognize. Let me ask you a question. If
I slashed you with a knife, just would that be an aggravated battery?
Yes.
If I just slashed you like this, would that be an aggravated battery?
Yes.
Right. And there may not have been really any intent for me to kill. It's just to slash it. That's the aggravated battery.
Well, I would disagree.
But we get into the manslaughter situation here where there's multiple stabbings.
Aggravated battery is you do the act, and in this case it's defined with a deadly weapon that's likely to cause death or great bodily harm. It's not the intent. It's the same intent as the attempted manslaughter. It's the exact same intent. I struggled with it looking through the jury instructions. How could it be different? When you read the facts of this case, and in particular Taylor, which cites over 100 years of case law, dealing with attempt.
I think it's a very, and again, I'm struggling what you're saying and thinking about it. There seems to be a degree in it. Committing an act that is likely going to lead to death. That I would think of that as attempted manslaughter, or committing an act that is likely to injure you but not kill you, such as just slicing you, that may be an aggravated battery. I think that may be the distinguishing point. It's just the degree of the attack or the act that led to the injuries. It's one thing to stab somebody 15 times. That's likely to lead to death, as opposed to just slashing somebody in a fight or something.
But aggravated battery is defined as an act that's likely to cause death or great bodily harm.
Or.
I understand that.
You don't have that in manslaughter.
It's proven both ways. I mean, it's presented to the jury both ways, and I think there's. So the attempted manslaughter would just be likely to cause death.
Well.
And so, I mean, that would almost be splitting hairs and seem like a repetitive jury instruction. How could it not be subsumed? Because there was no death. And there's no attempted aggravated battery. It's likely to cause death or great bodily harm. So it didn't cause the death.
But you wouldn't be using manslaughter as a lesser in a crime where at least attempted murder was not charged, or attempted second-degree murder. Whereas attempted battery could be charged where there's not this intent to kill.
I'm not sure I'm following exactly what you're talking about in the charging document. I'm sorry.
It just seems to me like, again, I'm struggling with it because I see what you're saying. It just seems like attempted manslaughter, as in this particular case, deals with, from what I'm seeing, just the feel I have for right now, for crimes where there are just multiple, the degree of the act that was performed was such a high, multiple stabbings type thing, multiple shootings type things are likely to lead to death, as opposed to just an act that it may perhaps is not likely to lead to death. I mean, I'm trying to find the distinguishing point.
And I would say that that's a distinction without a difference under the definitions of the crimes. And I recognize the struggle, but I think if we apply Montgomery, I don't know how you could have an attempted manslaughter instruction that is not going to be subsumed in the aggravated battery instruction. And I think this court doesn't necessarily need to apply the Montgomery analysis. I recognize that Gentry is a case that talks about the general intent and that you can extend it to the attempt in that case. But this court's rationale wasn't simply, well, we're saying it's a specific intent and you can do it. This court's rationale didn't want to do away with the crime, didn't want to reward the defendant, because there was no crime that attempted second-degree murder could be subsumed in, I would submit. It would fit nowhere else. Whereas now we're getting down to the, let's say, the third-degree crimes for purposes of the verdict form. I mean, the way they're listed and how the jury sees them and how the jury has read them and been instructed and how the case has been presented. Specifically in this case, the jury instruction was not an error. It specifically addressed the crime charged and the facts as presented. So I would suggest that this court needs to follow its prior precedent in Taylor and the 100 years before that, when this court has said attempted manslaughter is an intent to kill attempt. If there are no further questions.
Well, why don't we start here with how you would distinguish aggravated battery from attempted manslaughter?
Okay, well, first of all, I need to tell you that that was not raised in the state's answer and not argued below. So, but
makes it interesting.
Yeah, aggravated battery is a second-degree felony. Attempted and what was
attempted manslaughter.
And attempted manslaughter is a third degree. So that's
how would the jury instructions on the two crimes differ? Because as I understand the state's argument is that what you would be telling the jury for an for an aggravated battery would be the same thing that you would tell the jury for an attempted manslaughter.
To some degree, that is true, but that doesn't. The error occurred because the jury wasn't instructed on the next lesser crime, which is attempted voluntary manslaughter. So, being given two second-degree felonies doesn't cure the error that they weren't instructed on the next lesser crime.
Maybe I think that, and it may be because it wasn't raised, but we've got to get it right here, and we've got jury instructions before us that are either going to be changed or remain the same. I mean, we held off on that until this case was decided. But the elements of crimes have to be different. You know, I mean, you would agree. So the question that was raised is, and what Justice Quince is asking, I'm still not sure I got an answer, or she got an answer, is aggravated battery and attempted manslaughter. Where is, if one doesn't have, if they both just need an intent to do an act, then where are they different?
Okay, aggravated battery requires serious bodily injury, and attempted manslaughter does not. That's one difference I can think of.
Well, it sounds like the aggravated battery then would be the greater offense, and it's not.
And it's not.
It is.
It's
aggravated battery is the greater offense, isn't it?
Greater offense between the two.
Of attempted manslaughter.
Yes, from attempted manslaughter.
Okay.
It is.
Well, what's the next? I thought it was after attempted manslaughter.
That's the way the jury was given that, but in reality, it's not the lesser of attempted voluntary manslaughter, because attempted voluntary manslaughter is a third-degree felony. Aggravated battery is a second-degree felony.
Right.
So she's saying because they were correctly instructed on aggravated battery, is that the argument that we now have? They were given a correct instruction on aggravated battery.
And she says that negates the error in the attempted voluntary manslaughter. But it doesn't, because the jury was not given the next lesser down from second-degree murder.
Because the aggravated battery is the same
It's
degree
the same
as
as
the conviction, and the attempted voluntary manslaughter is the third degree.
Third degree.
As opposed to second.
Right. And so
under this theory, all this is driven by this jury pardon. I mean, because there's no credible, it seems to me, the facts here, there's no way this was an attempted manslaughter. I mean, with them stabbing her multiple times, that just seems to be, if the notion that could actually describe what happened here is fanciful. So it's all driven by the jury pardon idea, right?
Well, not completely, no, because the jury pardon isn't completely driven by that they have to be instructed on the next lesser. I just think they have to be instructed on the next lesser so that they can determine all the elements in the homicide crimes, or attempted homicide in this case, to determine which one they think fits the best. And so the fact that they weren't given a correct instruction on attempted voluntary manslaughter, the jury wasn't able to properly consider which attempted homicide offense they thought fit the bill. I need to address this. This court has found that there is attempted manslaughter by act in Taylor. Opposing counsel discussed an intent to kill, and true enough, Taylor does mention intent to kill in the body of it, but when it gets down to the holding, it holds that we reiterate, however, a verdict for attempted manslaughter can be rendered only if there is proof that the defendant had the requisite intent to commit an unlawful act. That's the holding in Taylor. Then later in Brown, this court again addressed it and talked about Taylor. And Brown held that, stressed that attempted manslaughter by act required an intent to commit an unlawful act. So going back to Taylor and Brown, this court did not find an intent to kill in attempted voluntary manslaughter. The state argues basically that you should resort back to the common law, and they rely on Section 77501, which tells us when we can apply common law, and it's when there's no existing provision by statute on the subject. Well, here, there is a statute on the subject because we have a statute on attempted voluntary manslaughter, well, attempted manslaughter, and manslaughter and attempt, so there's no need to resort back to the common law. In fact, it would be wrong to do so because once a statute's in effect, we're required to look to that instead of the common law.
And the statute says what on manslaughter?
Which the statute says?
What does the statute say?
Oh, God. I've got it.
Well, does it talk about intent to kill?
It doesn't talk about intent because it's defined by what it is not. It's a residual offense. It says it, not justifiable or excusable.
And that's
but
what we've been struggling with in Montgomery and before and after, right? Is that it? But it doesn't. It most certainly doesn't include an intent to kill as its element.
No, it doesn't. The statute doesn't. And also, it's the residual of what attempted first degree and attempted second degree are not, is what attempted manslaughter is. And it's different from aggravated battery. Aggravated battery requires use of a deadly weapon or serious bodily injury, which attempted manslaughter does not. I think that basically if you are to rule for the state, you would have to basically overrule Montgomery. And the state seems to be arguing that this is more a rehearing on Montgomery than anything else. This court was clear that there is no intent to kill in manslaughter. Therefore, it seems logical there is no intent to kill in attempted manslaughter. There'd be only an intent to commit an act, which would have caused the death, but it did not. We ask this court to follow the logic in Montgomery because it's correct. And in this case, Mr. Williams should be given a new trial with a correct jury instruction on the lesser included of voluntary manslaughter by act. Thank you.
All right, we thank you both for your arguments. That concludes today's session of court. We are adjourned.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Coming up on FSU Headlines, National Treasure, the Student Veteran of the Year, is one of Florida State's very own. Blast from the past, FSU celebrates classic design. And a Capitol affair, FSU Day at the Capitol brings Florida State to Florida lawmakers. Stay tuned for these stories and an interview with World Series champion Tony La Russa. FSU Headlines starts now. Welcome to FSU Headlines. I'm Scott Atwell, president of the FSU Alumni Association, coming to you from the Rotunda Green here at the Florida State University Law School. Later on in the program, we will speak with perhaps the most famous FSU Law School grad in history, who changed fields and wound up as a World Series champion. But first, let's find out where Florida State University is making news, here at home and around the world. Dennis Schnetker is standing by in the studio. Dennis?
Thanks, Scott. Florida State University recently announced its intent to become the most veteran-friendly campus in the nation. A key player behind that whole mission has been U.S. Navy veteran Jared Lyon. As a Florida State student veteran, Lyon was instrumental in bringing together FSU's first formal veterans initiatives. Now, his hard work has been recognized nationally. Lyon was recently named Student Veteran of the Year. FSU Headlines reporter Vanessa Wynn has more.
Hey, what's up, dude? How's it going?
Florida State University student Jared Lyon may seem like your typical college senior, but he's not. He's a veteran. Lyon served 4 years as a Navy diver aboard U.S. submarines before enrolling in college.
Yeah, I had a great time in the Navy. I joined the Navy and saw the world. That's like a poster or something like that, right?
But his service didn't end in the Navy. At Florida State, he was instrumental in addressing the needs of student veterans.
The needs of the veterans at Florida State are many. Mainly rooted here at the university, there are issues of transition. It's coming to a college environment that is largely unstructured by design, which is excellent for the regular college student making that transition from high school. But for a military veteran, it can be challenging. And we as a university owe it to our returning men and women from service to try to make this a better, more inviting, and more welcoming environment for them. Ladies and gentlemen, this initiative is incredibly important.
As a result of Jared's efforts, Florida State University pledged to become the most veteran-friendly public university in the nation. To prove it, Florida State will build a 35,000-square-foot veteran center to provide an array of services for student veterans. And none of it would have been possible without Jared Lyon.
This year's award for Student Veteran of the Year is Jared Lyon from the Collegiate Veterans Association at Florida State University.
Now, the Student Veterans of America have named Jared its 2011 National Student Veteran of the Year.
I think there was a lot of emotion before the award was actually given to begin with. Once they actually called my name as Student Veteran of the Year, I was just blown away. The incredible sense of humility that just overwhelmed me. And getting up, walking to the stage, and watching a standing ovation was something that I was almost brought to tears by. It's the culmination of over a year's worth of work at Florida State and the recognition of what my university is doing on a national stage. And it was truly an honor. It really was.
Jared and the CVA and faculty and staff at Florida State have worked very hard to support student veterans here at FSU. And so there's a great sense of satisfaction when someone who is deserving wins something or is recognized for what they've done. This award says it all. It's representative of all of the student veterans at FSU, though, and a lot of veterans that came before.
Jared is going to make history. I'm convinced of it. He's just the type of person we're going to see emerge as somebody that the country knows. How many students walk out the door and realize they helped change the university behind them? How many people sit back and say, I left that place better than I found it, and they're a student? What a great guy. He's going to be very successful.
As his time at Florida State comes to a close, Jared Lyon leaves a legacy marked with excellence and integrity for the next class of student veterans to come. I'm Vanessa Wynn reporting.
Thank you, Vanessa. Jared recently graduated from Florida State and is now the National Program Manager for the Entrepreneurship Boot Camp for Veterans with Disabilities at Syracuse University. We wish him the best. High-achieving Florida State University honor and grad students will soon have a place to call home in the heart of campus. Here's an early sneak peek at the project.
You're looking at the next big thing at Florida State University. I'm Karen Laughlin, the Dean of Undergraduate Studies at Florida State University.
And I'm Nancy Marcus, Dean of the Graduate School at Florida State University.
One of the new projects at Florida State that excites me is the development of a house for our honors students, our high-achieving undergraduate students, and our graduate fellows as well.
The object here is to get these students to come together, have a space, show them that we care so much about them. And I really do believe that this will be an excellent recruiting tool for bringing these outstanding graduate students to FSU.
The site that we have for this house is amazing. It's right on Landis Green. And in fact, ironically, it's on a street called Honors Way.
It's a wonderful location. Couldn't think of a better location.
The students that we've talked to are incredibly excited about this idea. They just see it as a place to showcase their accomplishments, to celebrate the things that they're doing, and really say to the community, Florida State values the contributions of these students. We really need a lot of support to make this building happen. So we hope our donors, our alumni, will really support this and get behind it and see it as something that's a real hallmark for the university.
And even then going beyond the facility itself is the programming that will go on within those buildings, and continued support for the honors program, support to bring graduate fellows to FSU. To get the best and brightest students requires competitive funding packages, and that's really what it's all about.
The Honors, Scholars, and Fellows House is scheduled to open in 2013. Florida State University is a national focal point for education research. That's why the federal government just awarded Florida State with a new $38 million contract.
Aliens and people are very different. What do you think?
Florida State University's Florida Center for Reading Research will help 6 southeastern states and their schools crunch the numbers to improve effectiveness. The contract will support the center and its research partners with operating the Regional Educational Laboratory for the Southeast region.
So one of the things that the REL is going to do is engage in a series of really highly structured, high-quality research on charter school effectiveness to figure out what are the characteristics that predict effectiveness, and hopefully that will enable policymakers to better govern the charter school sector and help them be more successful with their students.
Put it another way, the contract will help others understand the power of the information available to them and how it can be used to improve their schools. Well, still to come on FSU Headlines, those magic words every college student longs to hear.
We extend to you our sincere congratulations. You may now change your tassels from right to left.
Florida State University's fall commencement ceremonies, when FSU Headlines continues in a moment. Welcome back to FSU Headlines. I'm Dennis Schnitker. Good design is timeless, and nobody knows that better than the fine folks of Florida State University's top-notch Department of Interior Design. The always stylish FSU Headlines reporter Taylor Newsom joins us now from campus. I understand campus visitors can now see some examples of truly classic design in furnishings.
Yes, Dennis, that's correct. As you can see, some of these pieces may look like they were designed within the last decade. But in fact, these pieces were designed over 50 years ago.
An award-winning exhibit of Herman Miller furniture is on display at Florida State. The university's Department of Interior Design is curating the exhibition entitled Classic Herman Miller.
So Herman Miller stands up there with Knoll, Steelcase as a major producer of what we now consider classics. But because of the value of their design and the quality of the design, they seem just as fresh and contemporary today as they did when they were designed in like the 40s and the 50s.
I'd like very much for you to meet this very clever designer of this.
For people of different ages, the classic Herman Miller exhibition could offer a stroll down memory lane, or a stylish peek into the way their grandparents may have decorated their homes.
I think there's a lot a visitor, be they a student or someone from the community or faculty member, could get from an exhibit like this. Again, just the ability to see this many pieces of classic furniture in one place. You would generally have to go to a major museum to be able to see this.
Many of the same designs from the 40s and 50s can still be found in furniture stores and homes around the world, proving that classic design and good taste never go out of style. Reporting for FSU Headlines, I'm Taylor Newsom.
Thanks, Taylor. Florida State's interior design program ranks 10th in the nation among both public and private institutions. The Herman Miller exhibition at Florida State is on display through March 16th. Florida State University is on its way to having the premier arts research facility in the Southeast. FSU Headlines reporter Vanessa Wynn explains why and how.
Hi, welcome to FAR.
Step into the future at Florida State University's new Facility for Arts Research. Artists say this is where the digital and physical world come together.
The purpose of FAR, the purpose for the Facility for Arts Research, is to bring together a number of technological tools which all, in one way or another, use digital technology to make physical objects.
In other words, if you can think it, you can make it.
We can start with ideas and then at the end of the day wind up with physical objects. And these things can be objects of art, or they can be more utilitarian. They can be devices, they can be tools. We can make tools to make other tools is one of the things that we really want to concentrate on here.
The heart of the facility are these 3D printers which can replicate any two-dimensional object.
So this is the preview screen so that you can see what the model is going to look like.
After the image has been scanned into the computer, the machine prints hundreds of layers of the object out of this powdered substance. It's a long, detailed operation which includes vacuuming the excess powder and carefully dusting off the finished product.
It allows us to make things which would previously be very difficult or impossible to make.
The FAR building also houses a laser cutter and this computer numerical control, or CNC router, which uses a spindle to carve out precise images drawn from a computer screen.
The beauty of what I think is interesting here is the collaboration between the technologies, some of the older technologies like letterpress, and then combining that with laser cutting and 3D printing to make objects that artists couldn't make anywhere else, because there's nowhere else is there a facility that combines these kind of technologies.
Florida State University hopes to make the FAR building the premier arts research facility in the Southeast. I'm Vanessa Wynn reporting.
Thank you, Vanessa. The Facility for Arts Research is currently available for use by FSU faculty and visiting artists. The goal is to open classes to students in the College of Visual Arts, Theater, and Dance, and eventually the entire Florida State community. Faculty, staff, and students joined together recently in celebrating another university tradition, FSU Day at the Florida Capitol. That's where FSU Headlines reporter Jill Chandler filed this report.
The Florida Capitol is painted garnet and gold, and FSU alumni say they are proud to show their school spirit.
Can't you tell? I'm wearing garnet and gold. This is the best day of the session. Seminole Day, FSU Day is where we at least kind of show our enthusiasm and make sure that the Seminole Nation is alive and well in the Florida legislature.
President Eric Barron bragged on Florida State and its great accomplishments of the year.
It's also wonderful to see how many Seminoles are serving this state as elected officials, legislative staff, and FSU interns.
One thing that binds us, Democrat or Republican or North Florida or South Florida, is that today we get to all be Seminoles.
The alumni of Florida State who serve as legislators were recognized for their hard work.
Oscar Braynon from Miami Gardens.
FSU Day at the Capitol may only be one day of the year, but FSU alumni say their Seminole spirit will last all year long. I'm Jill Chandler reporting.
Florida State University's integration statue stands as a powerful symbol, recognizing the past and celebrating the future. The larger-than-life-size bronze sculptures proudly depict the university's first African-American students who achieved success in academic, athletic, and social integration, blazing a trail for countless others who followed. And now Florida State is taking measures to make sure the monument will stand the test of time. Omnipresent Headlines reporter Vanessa Wynn shows us what it takes to preserve it.
With this propane torch, these employees carefully touch up one of the largest and most important statues on the Florida State University campus. Manager of Outdoor Amenities John Rollerson says it's more than just a two-step process to protect this treasured campus monument and others like it.
These sculptures and statues are visual representations of our heritage. And as a campus and a place of education, I think it's extremely important. These outdoor monuments kind of create a situation where we have an outdoor classroom. So we have the historical aspects, the educational aspects, and then quite frankly, bottom line is a monetary issue. You know, the idea that we would invest so much in fine art and then not take care of it would be ludicrous.
The integration statue depicts the African American students who first achieved academic, athletic, and social integration at Florida State University. The monument's bats, books, and beauty theme represents Maxwell Courtney, who was Florida State's first African American undergraduate student, Fred Flowers, who was the university's first black athlete, and Dobby Lee Flowers, FSU's first African American homecoming princess. Her image is a historically accurate representation of Florida State's homecoming costume of the early 1970s.
What we do is we heat the sculpture up section at a time. As we heat one section and drive that moisture out, we immediately come back in with a paste wax. And when we apply that wax on the hot bronze, it melts the wax and it soaks into the pores of the bronze. Then as that area cools, we heat the next section.
He says the goal is to practice preservation before restoration.
If we actually have to do restoration work, then can be sandblasting involved, and then chemical treatments to get our color back, and then a protective coating.
Rollerson estimates it will take roughly 40 hours to complete every inch of the integration statue, but it's worth every bit of their time as they preserve history for future generations to remember and celebrate. I'm Vanessa Wynn reporting.
And John Rollerson plans to touch up every sculpture on Florida State's campus every 3 to 5 years. This past December, more than 2,300 students successfully reached the end of their academic careers here at Florida State University, but not without first learning some final lessons.
If you're not nervous, you're not ready. It means you don't care.
For some, those final lessons came courtesy of Florida State University alumnus Tony La Russa. You may recall La Russa just claimed his third World Series championship as manager of the St. Louis Cardinals. The future Hall of Famer announced his retirement from baseball just days after that victory, and shortly thereafter returned to his alma mater to remind his fellow Florida State alumni that graduation is a day for celebration.
This is a significant day for the graduates. Learned a long time ago to enjoy the moment. You don't have moments like this all that often. Understand, realize, appreciate what you've experienced. Graduating from college is a major achievement, and it is a time for celebration. There's no limits to what you can do if it becomes important to you. So I congratulate you.
Florida State holds 2 commencement ceremonies in the fall, so La Russa split the speaking duties with Florida State University faculty member Jawole Zoller. The professor of dance is a bit of a motivational speaker herself, and she knows how to fire up a crowd.
I made it! I made it! Yes, I did! I did! I did! I made it! I made it! I made it! I made it! Yes, Lord, I made it!
Colleen Ray Mathis. Congratulations again to the class of 2011. That's going to do it for your look at the news from campus, but stick around. When we come back, we'll sit down with Tony La Russa, the man who inspired so many at the commencement ceremonies and beyond.
The quality of your character, your determination to be special and distinguish yourself from everybody else that may be competing against you is going to determine, what you become. And that's a very personal commitment you make. I'm going to try to make that point without preaching,
You don't want to miss this. A pep talk from Tony La Russa when FSU Headlines continues in a moment.
Welcome back to FSU Headlines. I'm Scott Atwell, president of the FSU Alumni Association. For years, this green outside the FSU Law School has been a field of dreams for some of the best law students in America. But one of its graduates longed for a different field. And this past fall, he wrapped up a remarkable baseball managerial career with an improbable World Series victory, his third as a major league manager. His name is Tony La Russa, FSU Law School class of 1978. And not long after that victory, he was back on the FSU campus as a commencement speaker. And we had the chance to sit down and speak with him. I don't think there's a baseball question you haven't been asked, so I'd like to talk mostly about law school. What is the road? Tell us about the road that led you to Florida State's law school.
Well, I had the dream of Major League Baseball as a young kid in Tampa, Florida. Signed out of high school, went into a professional career and played 16 years and didn't work out. Just wasn't good enough. So towards the last 5 or 6 years, I realized I'm not going to make it. You do something else for a living. I always liked to read, liked problem solving. I had friends who were lawyers, and I said, law school. So I took the LSAT, came to Florida State. Have never regretted it.
While you were in law school, you started to have this idea about managing baseball. How did you balance that dilemma of trying to finish law school, but also trying to plan for a career in baseball as a manager?
When I started law school, I knew that my career was going to be over. As soon as I finished law school, I was going to be an attorney. Because it just wasn't good enough to make a living. I mean, a legitimate living. But the last 3 years, it took me 5 winters to do this. The last 3, I was a player coach. The last year that I played, which was the summer of '77, I began my last 2 quarters and I was going to graduate. So we decided that since we didn't have family at the time, and you couldn't take the bar and get all the results till the winter, why don't we just manage 1 year, the summer of '78, get it out of our system, get it out of my system. And it worked out great. And then they gave me, I said, well, we'll go back for '79. That was AA. Then next year was AAA. And in August, I'm the manager of Chicago White Sox. Now, interesting about that is the owner was Bill Veeck, who knew about the law degree. And he made me promise that I would take the bar if he gave me the job. I got it for the last 50 games of the year. He says, before I give you the job for 1980, you must promise to take the bar. In other words, he's trying to tell me there's no security and you better have it to fall back on.
Did any of this law school education apply to what you did as a manager in baseball?
Well, I like to answer that because as I survived the first few years, people kind of blew it out like maybe it was more than it was. The way you survive is to have good players and have a good organization behind you. That's the key. And I would point out to guys like Sparky Anderson, Billy Martin, Earl Weaver, these Hall of Famers, that one of them sold cars during the off season, sold insurance. I mean, it would. But in my case, I think there was a direct connection because I signed to manage the big leagues after a lousy playing career in parts of 2 years managing the minor leagues. So I didn't have that 9, 10 years managing the minors, which is the preparation you have. So what I did to try to catch up, the veteran manager and hear what he offered his team and what I offered, I tried to narrow that gap by just preparing my butt off, stuff that I used in law school. I mean, I got to where I could take all the material that I was given about the team we were playing, and I could get through it quickly, and I could organize it, so there's no doubt in my mind that I survived and was able to prepare to narrow that gap some because I had the legal training.
On this trip back, you get to have an audience with students, with graduates. What is the message that you want to get across to them?
In the end, they need to understand how important it is to take personal responsibility for where their life goes. That degree will only get you an opportunity, a foot in the door, an interview, the quality of your character, your determination to be special and distinguish yourself from everybody else that may be competing against you is going to determine, what you become. And that's a very personal commitment you make. I'm going to try to make that point without preaching And I'm going to tell them what I believe. I'm a great believer in competition. I think it's a wonderful philosophy to adopt, embrace the pressure of trying to win the competition, do it in a way with integrity. I think it brings out the best in you, and if somebody beats you, tip your cap. So, I mean, it's stuff like that. I'm going to congratulate them, but I'm going to try to challenge them.
So many people in athletics have an opportunity to finish on top, to do what you did, to go out as a champion, and they fail to do it. Why is that?
I think that's a great question, and I hope everybody hears this answer so I don't have to keep answering it. And that is, it was totally accidental. I mean, if we'd have finished in last place, I was done. The difference was, since we finished well, I was asked to return, and they tried to talk me out of it, which I appreciate. But a lot like what I'll tell the students here, you make a personal commitment to yourself first, that you're going to try to get to where you need to be successful. If you start having trouble getting there and you have to really work hard, at some point it gets too hard. And if you start feeling like, I'm going to run the risk of drop below that line, then you're a fraud if you take a job, even though you may fool them. I probably could have for a couple of years. And I just felt like time was up. I decided mid-season. The fact that we won a world championship is just a fairy tale finish to the career. And I could say I left on top, but it just worked out that way.
Well, Tony La Russa, thank you for taking time, and thank you for making us proud. That's going to do it for this edition of Florida State University Headlines. The FSU Alumni Association is a membership-based organization. If you or someone you know would like to become a member, the information at the bottom of the screen will be helpful. On behalf of the 290,000 FSU alumni around the world, I'm Scott Atwell. Thanks for joining us. We'll see you next time.
Hello, I'm Jules Graham. On this edition of Dimensions, we'll get a sneak preview of the Mag Lab's annual open house. It's a very popular event. And we'll find out about two other annual events, the Capital City Senior Games and the Italian Family Festa. All that and a trip to the garden on Dimensions. Welcome to Dimensions. I'm Jules Graham. February is all about love, and we love to spread the word about interesting activities in our area. In an effort to spread the science bug, our own Mike Plummer has found his way into the Mag Lab.
So it's called Jacob's Ladder. So it's